Can I just check? Can people hear me at the back? You can. Thank you. So it's, sorry, you okay, sir? It's now 10 o'clock and the inquiry is now open. My name is Leslie Coffey. I'm a chartered town planner and I've been instructed by the Secretary of State to conduct this inquiry. As you may be aware, the Secretary of State recovered the appeal late last week for her determination. The reason given for this was that the appeal involves a proposal for residential development of over 150 units on a site of over 5 hectares that would significantly impact on the government's objective to secure a better balance between housing demand and supply and create high quality, sustainable, mixed and inclusive communities. In practical terms, what this means is that I will provide a report to the Secretary of State summarising the cases for the parties, reaching conclusions on the issues and then making a recommendation. It's an appeal made by Hallam Land Management Limited under Section 78 of the Town and Country Planning Act 1990, and it's against the failure of Fareham Borough Council to determine the application within the prescribed period. The application is for up to 1,200 new homes, an 80-bed care home, a new 2-form-entry primary school, a local centre to include flexible commercial floor space, a community centre, a healthcare facility, and the formation of a new means of access onto Longfield Avenue and Peak Lane. It also includes new open space, including the laying out of a new country park and sports facilities, drainage infrastructure, walking, cycling infrastructure, and other works. The only matter, it's an outline application, and the only matter for determination at this stage is the access. And the appeal site is at Longfield Avenue, Fareham. Can you just bear with me while I get some water? It's struggling. Oh, thank you. Excellent. Thank you. Lovely. The council considered the application following the submission of the appeal on the 8th of August 2024, and it resolved that had it been able to determine the application, it would have refused permission. Essentially, its putative reasons for refusal were that the scheme failed to secure the delivery of the 40% of the permitted dwellings as affordable housing, the delivery of an extra care facility, secure the delivery of adaptable and accessible standards for a number of the dwellings in terms of mobility, the delivery of service plots for housing to be either self-build or custom build, the delivery of sustainable transport improvements, mitigation and safety schemes for off-site and local strategic highway, the management and maintenance of publicly accessible open space, the management and maintenance and delivery of the bird reserve, the delivery of the community facility and local centre, and the provision of a financial contribution towards off-site healthcare provision, the delivery of sports pitches, early years education provision, primary school on the site, and a financial contribution towards the production and monitoring of a school travel plan. It also, the reasons included the absence of a financial contribution towards places for pupils with special educational needs and disabilities, the absence of a financial contribution towards secondary school capacity, failure to secure an employment and skills training plan, and a financial contribution towards upgrading public rights of way. So just before I go any further, could I ask people if they've got phones with them that they could either turn them off or to silent and audible notifications for emails off? I also just need to point out that I understand we're being live streamed. No, we're not being live streamed. We are being live streamed. That was my understanding. And therefore, if you are speaking, you'll be recorded. So I would ask you not to put any personal information out there. If perhaps if there is anything of that nature, you could talk to, it's not Hebden, is it? It is Hebden. Miss Hebden from the council. Just have a quick word with her and perhaps she'll make a suggestion as to how we could facilitate that. So I have got a number of other matters I need to cover before we move on and hear the cases for the parties and other evidence. Just before I do that, I want to advise you that there's no planned fire alarms today. And Miss Hebden, I think, is going to cover what happens should there be a fire alarm. Sorry, could you turn your microphone on? I'll put mine on.
If there is a fire alarm, it's not a drill and we are to use the staircase rather than the lift, I will direct you to the staircase and we will meet in the car park outside the civic offices. Thank you.
Is there anyone, because we're not allowed to use the lift, is there anyone that needs assistance if we do have to leave? No? Thank you. And I should also mention that the toilets, if you go out of the corridor here, you come to the gents first and you go through some other doors and the ladies and disabled are there. Thank you. There's a number of matters that I need to cover, so do bear with me. And then I'm going to ask the main parties to introduce themselves and I'll outline the procedure for the inquiry and clarify a few matters in relation to the appeal. And I'll then identify the main considerations and the programme for the inquiry. I think that might have been added to the website, I'm not sure. Has the draft programme been added to the website? Has, thank you. I'm going to pause as I go along, and if you've got any questions, if you raise your hand, I'll try and answer them. So I'm going to start with the council. Who appears for the council?
Ma'am, good morning. I do. My name is Paul Shadarevian, King's Counsel, and I will be calling 3 witnesses. That's Stephen Jupp, Planning and Sport and Recreation, Valerie Ballerin on Highways from the County Council, and Mr. Mark Sanders on Education from the Local Education Authority. And not my witness, but who will be appearing as an interested party on behalf of the ICB is Malcolm Dickin, whose correspondence you've had. Malcolm Dickin, D-I-C-K-E-N, whose correspondence is before the inquiry. Thank you, Mum.
And for the appellant?
Good morning, ma'am. My name is Thomas Hill, H-I-L-L, King's Counsel, and I'm instructed by Mr. Owen Jones of LRM Planning, who sits immediately on my right. Ma'am, we've got a short list of appearances to save your hand. Just see if Ms. Jones would be kind enough to pass those round. But they are as previously advertised at the CMC with no changes. Mr. Jones will be dealing with planning matters, sport and recreation, and also public rights of way, and also some of the issues of broader application. And then Mr. Goodman is here today to deal with any matters arising in respect of ecology. I've flagged up in the draft programme how that might be dealt with, subject of course to your views. Mr. Hunter is here to deal with healthcare and education, we hope tomorrow. Ms. Baker is here to deal with highways and transportation, but excising public rights of way, which is more the province of Mr. Jones, as indicated earlier. So, ma'am, those are all as advertised at the CMC with no additions or subtractions.
Thank you. In terms of other people who wish to address the inquiry, I have Mr. Bob Marshall. Is Mr. Marshall here? Mr. Marshall, how long do you think you require?
I've got a very short written statement. It goes to about 3 pages of A4. I've got a copy of it through this afternoon for both parties.
That's very helpful. So I suggest probably 5 to 10 minutes would be sufficient for you.
Yeah.
Yeah.
Well, I understand it's going to be by round table session rather than by use of presentation of voting. Obviously, I can make my group and my statement earlier on to the stage. What role can third parties play within the way in which we're conducting the inquiry in the grant? I don't anticipate really participating at all, but if something came up that was a comment on it, into your eyes.
If something came up, if you raise your hand and put your point through me, and if it's relevant, we will look at it and discuss it. That's probably the best way because forward in this particular case. So you're not excluded from the roundtable discussion. We'll try and address the matters that you raise, right? But obviously no new technical evidence. All right, thank you. Is there anybody else wishes to address the inquiry? So there's 2 ladies at the back on sitting next to each other at the back, and then I'll come to the lady at the other side. So if you want to just stand up and give me your name. Councillor? Yes, thank you. And are you supporting or opposing the scheme? Okay. And how long do you think you? I'm quite happy for you to participate during the highway session, but it would be helpful to have an overview of what you wish to say. I think the other reason for this is because it's the Secretary of State will be determining it. To have a written summary, much as Mr. Marshall's indicated, is very helpful because I can make that one of the inquiry documents that the Secretary of State will see, rather than just my note of what you said. So my report would provide a summary, but if you give me if you put what you want to say in writing, we can add that as an inquiry document, which I think is probably to your benefit. Thank you. So again, probably 5 to 10 minutes this morning, and then further participation later. Yes, Madam. Councillor, sorry, it's very hard to hear from this distance. Jackie. Thank you. And you're opposing? Yeah. And how long do you think you need? 15 minutes. I think when you're addressing the inquiry, it's better if you could come to the table and use the microphone. I know I'm struggling. I don't know if the people at the back are struggling, but you're a bit closer, so you might not be. Okay. No, in a few minutes, but thank you. And there's a lady on the side of the room. Anne Richards. Is that Anne with an E or no? And are you supporting or opposing? And how long do you think you require? 2 minutes. Thank you. Is there anyone else who wishes to address the inquiry? Thank you. So again, anyone that's addressing the inquiry, if they're able to provide a short written summary of what they want to say, that would be helpful. I've seen the site notices and the letters of notification, and the representations made at the time of the application will be taken into account in my decision. I should also say that I held a case management conference in September with representatives of the appellant and the council, and that was to discuss the procedure at the inquiry and not the merits of the appeal. We covered issues such as the timetable for the submission of evidence, the running order, the inquiry library, and likely main issues. In terms of proofs of evidence for the main parties, I've got proofs of evidence from Owen Jones for the appellant, Jenny Baker, Ben Hunter, essentially all the witnesses that have been introduced, and Mr. Goodman. Again, I have proofs of evidence from the the local planning authority witnesses, and rebuttals in terms of the health and highways issues. The health is not a council matter, as I understand it, council witness. Thank you. So I have some statements of common ground between the main parties. I've got a planning statement of common ground. This sets out the matters agreed and not agreed. And I think it's probably helpful to say at this stage that the main parties are agreed on the principle of development, and that the differences relate largely to mitigation measures in terms of highways and a number of other matters that I'll come on to in a moment. But the principle of the development is not in dispute, and I think that's also apparent from the council's putative reasons for refusal. I've also got statements of common ground in relation to transport, education, and public rights of way. And I'm aware that discussions have been continuing between the parties, and they probably continue. Yes, sir. I think. Did I not see you?
Well, no. I don't wish to address the inquiry today, but I'm here to Hampshire Council in regards to the rights of way network.
Sorry, you're here too. Right. Absolutely. You, Mr. Millard. Thank you. Mr. Millard will have, when we're dealing with the highways issues, I want to deal with the road issues first, and then we'll deal with the public rights of way. I think that's the logical way. Thank you. So, as I said, I've got a number of statements of common ground, but I'm aware that the parties have been continuing to work with each other. And I think it would probably be helpful if towards the end of the inquiry, maybe for Monday, there could be an updated statement of common ground, because I think matters have narrowed further probably since the ones I received. Okay. So for those not familiar with the procedure, I'll just outline the procedure now. I'm going to be following the inquiry procedure rules. We're programmed to sit for 8 days, but I think we'll probably complete it within 5 days. And we'll be sitting Tuesdays to Fridays, so that's Tuesday to Friday this week. Although Friday, I think at the moment, is identified for the site visit, and then Tuesday next week. And I'll try and indicate at the end of each day where we've got to and what we'll be moving on to the next day. So I'm going to start by asking the council and the appellant to make short opening remarks. Then I'm going to hear from the parties that wish to address the inquiry. And then I will hear the evidence on a topic basis. I'm going to, before I move on to the main topics that are in dispute, Mr. Goodman is the appellant's ecology witness, and I don't think there's a difference between the council and the appellant on these matters, but there's a few questions and matters of clarification I have for Mr. Goodman, and I will deal with that first, and then we'll move on to the highways issues. So as Mr. Marshall's indicated, it's a roundtable discussion that I shall lead, and its main purpose is that I get the information I need to inform my report. And if other parties wish to raise something, that would be an appropriate point to raise it, and I will check as we go along if there's anything that you need to add. So after the highways issues, the programme changed a little bit. We then hear tomorrow, it's hoped that we will hear the health conditions and issues, followed by sports and recreation issues, and education tomorrow. On Thursday, we have Right Honourable Suella Braverman MP wishes to address the inquiry. That will be at 10 o'clock. And then we'll return to any further outstanding issues we've got. We have a site inspection programme for Friday. I've looked at the general location of the site and the surrounding roads, but we'll carry out an accompanied site inspection. The itinerary, I'm not sure if that's been added to the website. I don't know if... Right. I don't know if it's essential, but it could be made available for the public to see if they wish. And then on Tuesday next week, we'll have a final roundtable session on the planning conditions and the obligations. I just want to say that although we're looking at the planning conditions, that's to make sure, that's to have that discussion with everyone present and make sure that they're appropriately worded. It doesn't mean that I've made up my mind as to the recommendation. It's just a useful way of checking them with everyone here and taking account of different views. We'll take a short break each morning and each afternoon, and we'll try and break for lunch sort of 12:15 to 12:45 at an appropriate point there. I think in this particular case, we'll start at 10 o'clock each morning, because I think that gives the parties time to deal with housekeeping and any ongoing negotiations. Moving on to the plans on which the council based its decision, and the plans on which I'm being asked to determine the appeal, are listed in the statement of common ground. What would be helpful to me would be if I could just have a short list of the CD numbers for the plans, And I think I mentioned a couple in my note that I sent out last week that so on my third bullet point, the highway access plans at paragraph 3.7, they've been submitted, but they're referred to as not part of the application. I'm assuming that they should be for determination. And I think in a couple of cases, I don't have the most recent version of the plan. So if that could be checked, I don't think we should spend inquiry time on that. The gentleman, did you want to say something, sir?
Yes, ma'am. I'm Stephen Sharp, given in essence the planning evidence. As I understand it now, the various highway plans have been agreed, but they're not online yet as core documents, and we haven't got a final schedule yet that we can hand you, but we'll arrange for that to be done as soon as possible.
That would be very helpful, and just so that I can find them easily, because there's quite a number of documents there. Thank you. The one other point that I raised in my note was that there's reference in. Sorry, I had there's reference in the in, I remember if it's a highway statement, but CD's 12, I think. There's reference to the appeal decisions at CD 12, but I don't seem to have that on the website. In fact, it doesn't go in numbers like that, it goes in letters. Could that just be looked at and resolved? Because it's not just me, it's the Secretary of State. We'll need to find the documents. So just, again, it's just a housekeeping matter that could be looked at outside the inquiry. I can't remember who references them.
Just on that, I think it was probably the ICB in their submission indicated they'd supplied 12 appeal decisions, but they hadn't. And we've been chasing for those, and they were supplied at the end of last week. So not within the timetable. We have been trying to get on top of those. There's 216 pages of them, but they have, I think, now been uploaded, and they have a different reference. And
we could keep the reference that's on here and just put an asterisk saying that reference to CD12 actually means whatever, if that.
Yes.
So I think that's disrupting the whole filing system otherwise. Okay. So if they're added, and I think that was the main parts there. So can the appellant confirm that in terms of the reserved matters, it's just the access to the site that's sought for approval, not internal routes? Thank you. So if there's nothing else, I'll just identify what I consider to be the main issues. So as I said, the principle of development isn't in dispute. So whether having regard to the submitted unilateral undertaking, together with the suggested planning conditions, the proposal would make satisfactory provision for and/or mitigate the effect of the development on education, the highway network, including public rights of way, GP services, and the delivery of the community centre, local centre and sports hub required by policy HA 55. I also understand that I did understand that the mix of the dwellings of the care homes was satisfactory. And then I've read something that brings that into question. Is there any dispute between the parties about the mix of dwellings in the care home?
Ma'am, I think this is something that's very recently been clarified. I think it's been clarified in a way that's satisfactory to both parties. And I will address you very briefly on it in my short openings. But I think there was a misunderstanding. I think that's subsequently been very recently been resolved to our satisfaction in relation, in particular, to the extra care. I don't think anything's changed in relation to the care home. But there was a question raised by Mr. Jupp in relation to the extra care, and we've heard back this morning that there is a means to move forward on that, so that it needn't be something that troubles the inquiry.
Thank you. Obviously, as you're aware, I'll have to prepare a shadow habitats assessment, but looking at the documents, I think that I've got the information I need, subject to some clarification on a few points from Mr. Goodman. So do the parties wish to comment on the main issues?
No, ma'am, I think that's a very sensible list, if I may say so, and it's certainly not appropriate to delve into further detail as you open the inquiry, because things are changing day by day, hour by hour, as you might expect, and we are moving towards a greater degree of concord, I'm happy to say. But no, I don't have anything further to add. As I said, so, in the draft programme that we agreed, Mr. Goodman is here, and we thought it best to get him on early in relation to the shadow HA, so that if you did have any requests, he could work on providing a note in response to those that you could then have regard to when you were preparing your report.
Thank you. So is council happy as well? Thank you. Are there any other issues anyone else wishes to add? No? Thank you. In that case, I will move on and ask the council to do opening remarks.
Just before we do that, could I just ask in relation to the live streaming? We weren't aware that these proceedings were going to be live streamed. We don't object, but we're not aware of how that link can be accessed. We weren't notified about this. Is there anything that can be provided to us to enable anyone on our side of the room who'd like to follow the proceedings remotely and not attend in person to take advantage of that opportunity?
The link should be available on our website. The link to the live streaming should be available on our website.
Thank you. It's helpful.
Ma'am, I've put my very brief opening submissions in writing. I'm going to circulate them now, and they are very brief. Could you give one to Inspector and one to Tom? Oh, I thought there were more copies available, so sorry. So, ma'am, I make these submissions on behalf of the local planning authority, and to the extent that it supports the cases made by the local highways authority and the local education authority for appropriate Section 106 obligations and conditions as set out in their respective proofs of evidence, rely upon this evidence in support of its case on highways and education grounds consistent with the requirements of relevant development plan policies. The NHS is a consultee, and although the LPA supports its case for the contribution it seeks towards capital funding of primary healthcare facilities to support the future population, it will appear as a third party, not being part of the two-tier authority whom I represent. Just to be absolutely clear about that. It may be said from the outset that the only matters separating the local planning authority and the appellant are those issues relating to the question of what conditions and Section 106 obligations are required to make the development acceptable. There is no question but that the appeal proposals represent the single biggest residential allocation in the borough, Wellbourne aside, which is a case on its own, and that it therefore represents a very important component of the borough's future housing supply. It is in the public interest that development commences in a timely way, but that it does so subject to an appropriate regime of conditions and obligations to ensure that the development proceeds in an orderly fashion. This means that the impacts of the development should be properly and appropriately mitigated, and that the development itself should be sustainable. It is the local planning authority's case that this can only be reasonably achieved by the obligations and conditions it seeks. The impact which the measures sought will have on the viability of the development in financial terms is not an issue before the inquiry. It is not the case for the appellant that the imposition of the conditions and obligations which are sought by the local planning authority would have an unacceptable impact on viability. Ergo, it is not being suggested that some impacts will have to be accepted as part of the planning balance. The simple question for this inquiry is whether what is being sought meets the legal and MPPF tests for conditions and the CIL-Reg 122 test for obligations. That is what this inquiry should be interrogating and deciding. Whether CIL monies might be available to fund some of the infrastructure in the future is something of a red herring. The exercise of future spending powers under the CIL regs and the decision to allocate spending towards any of the array of legitimate borough-wide infrastructure projects is an executive function, and it is wholly discretionary. The requirement being that the council produces its annual infrastructure funding statement pursuant to CIL Reg 121A. It is not for this inquiry or this decision-making function to preempt or anticipate the outcome of that discretionary process. Thus, if the CIL tests are met in relation to the obligations sought, that is all that matters. And I will deal with this at greater length in closing if there's a need to do so. In the context and within the timetable of this appeal, there has been considerable dialogue between the parties in order to see whether compromises could be justifiably reached, and some progress has been made. It might be that through the mechanism of roundtable discussions, further progress can be made, and we are certainly open to that and shall cooperate with you, Ma'am, and the appellant's team to help narrow the gap so far as possible. I'm not going to deal in detail with specific areas of dispute, but would make the following in principal points for the purposes of this opening. The fact that a specific item of infrastructure may perform a broader community function is not uncommon. Indeed, the provision of community infrastructure, which is needed for a particular development, should integrate in a way that promotes social cohesion and integration. The essential issue is whether the required infrastructure is necessary to support the needs of future population of the proposed development and to make it sustainable. The fact that it would perform a broader function does not per se take it outside the requirements of Regulation 1222C, with the effect that it should be disregarded as a consideration whether permission should be granted. There is nothing under any head in this case that would come within this category. A similar point could be made in relation to an item of infrastructure that is needed to prevent unacceptable harm occurring through the use of the proposed development. Forgive me, there's an odd full stop there. In the case of highways improvements, for example, the fact that the proposed development is predicted to have by far the biggest impact on a particular junction, which without mitigation would cause unacceptable impacts on highway safety or other severe residual cumulative impacts, applying paragraph 115 of the MPPF, could well justify a full contribution if there is no other way in which the intervention will be funded and delivered. Again, this does not take it outside the requirements of Regulation 1222C and should, in my submission, be a reason for granting permission in such a case. In other cases, it may be appropriate and reasonable to apply an apportioned approach and require a proportionate contribution that reflects the fact that the item of infrastructure will be or would be likely to be funded from more than one source. In these circumstances, it would not be reasonable to insist upon a full contribution and would most likely fail Regulation 1222A and C requirements. The site was, of course, reassessed following receipt of the SIL examination inspector's recommendations, and SIL was adjusted for this site to account for the Section 106 costs, which were then forecast. Now, I deal very shortly and in outline with the subject heads. Highways. In relation to highways, further consideration of the headline ask has been given to some of the identified improvements and interventions, and for reason you will hear, a large measure of agreement has been achieved to date, though there do remain some fundamental differences on key items of infrastructure. With respect to IDP schemes, items B2 to B4, D8 and D9, which we say are directly and significantly impacted by the development, fully justify future capacity and safety interventions, given the proximity of the site to these junctions and the scale of the proposed development. Education. The Education Authority is, of course, concerned to ensure that appropriate primary school capacity is available to the children at an appropriate stage of the development, and that up until that time, adequate capacity is available in existing primary schools within 2 miles of the application site. The local planning authority is keen to ensure that this is the case because it is fundamental to the sustainable operation of the proposed development and the well-being of its future occupants. There is a difference of view between the appellant and the local education authority as to what capacity will, in fact, be needed as a function of child yield, although it is difficult at this outline stage to be confident about the figure, so a cautious approach should be adopted. The local education authority estimate is that the development would have the potential to generate the need for a 1.2 form of entry based on the LEA standard assessment criteria. For reasons explained, it is not practical or possible for primary schools to be constructed at sub-half FOE increments. Hence, a full contribution is required to fund a 1.5 FE school because there will be no other funding available. The contribution sought is therefore the provision of a serviced and developable site and sufficient funds to allow the school to be built. It is the LEA's position that there are no identifiable additional funding sources available. The importance which government places on education provision as part of its growth agenda is clearly set out in the recent DFE 2023 guidance, and we say that the contribution sought aligns with this guidance. Reflecting on the appellant's rebuttal evidence, the LEA no longer requests contributions towards pupil travel costs in a shorter term, and the local planning authority supports this concession, provided that safe cycling and walking routes exist to facilitate non-motorised journeys from the site to the various local schools pro tem. Primary healthcare. I don't repeat what's been clearly set out in the correspondence from the NHS, from the ICB. The Council is concerned to make sure that there is sufficient primary healthcare capacity to service the development in the medium and long term. And Ma'am, if I may just pause here, we're not seeking revenue contributions, it's capital. And we are not seeking contributions towards secondary or acute healthcare, which plainly have been the subject of a lot of judicial discussion. This is simply for capital funding for additional surgery space. A contribution is sought to be used to expand Fareham Medical Centre or such other existing or proposed site as notified by the Council, if the ICB so advise the Council. The contribution we are seeking of 721,000 is sought as a function of dwelling yield. The local planning authority has no rational basis or justification to depart from the reasoning advanced by the ACB in this case, and does a view that what is required is both reasonable and meets the SIL tests. Sport and recreation. This has been a subject of further consideration by Mr. Jupp, you will hear in due course. And the current proposal from us is that we are seeking the 4.3 hectares of land, service land, which is being offered, which is in excess of the strict policy requirement for, but I think aligns with the supplementary planning guidance, to be transferred to the Council of which 3.45 hectares will be sports pitches based on SPD requirements for the site. The council would create and maintain the pitches, utilising a sum to be paid by the appellants. That's a total of 3.157 million. This sum would also be used to provide and maintain changing rooms for 4 teams and officials and a community area of 0.03 hectares and a 50-space car park covering an area of 0.1 hectare. So we say if you take into account those additional areas for the building and the car park, the development justifies a total of 3.58 hectares based upon the need for facilities generated by the development. Hence, we acknowledge that the additional land which is being sought of 0.72 hectares is required to fulfil the HA 55 Appendix D master plan, and it follows that the value attributable to this additional land should be subtracted from the overall contribution sought. We have yet to agree a formula for that, and further discussions, I hope. Yes, yeah. I'm hoping that this can be the basis of further discussions between the parties in due course, but that sets out our current position. And it's in tabular form here, so I can circulate this. Not expecting this. Then, Mark, there's my opening submissions.
Thank you, ma'am. I'm just circulating or having circulated a copy for yourself and for my learned friend. I'm afraid I've only got a couple of copies rather as he did, but more can be provided if necessary during the course of the day. But these are what it says on the tin, short opening submissions on behalf of the appellant. Ma'am, this appeal has been brought by Hallam Land Management Limited, the appellant, against the failure of Fareham Borough Council, the local planning authority, to determine its planning application within an agreed period of time. And it's important to recognise that that period of time had been regularly extended by agreement over the course of 4 years since the application was originally submitted in 2020. And during that 4-year determination period, or non-determination period, we would say, the status of the application site has evolved from a potential strategic development area in an early consultation document to a fully allocated site, HA 55, in a recently adopted development plan, the Fareham Local Plan 2037, which, as you know, ma'am, was adopted only last year in April. Thus, for 18 months now, the full statutory weight of the development plan has been underpinning the appeal proposals. And it would not be unreasonable to ask why, against this background, the appellant has felt obliged to pursue an appeal to the Secretary of State. The answer is simply that the appellant had, by June this year, formed the view that there was no other available means to bring discipline to the essential process of resolving outstanding matters in relation to this application, and in particular to ensuring that the local planning authority, the highways authority, the local education authority, and key statutory consultees such as Natural England and the ICB turned their minds, both individually and collectively, to the application of Regulation 122 of the SIL regs as amended, so as to ensure that in each case, any contributions sought from the appeal development are A, necessary to make the development acceptable in planning terms, B, directly related to the development, and C, fairly and reasonably related in scale and kind to the development. By June this year, over 12 months after the status of the application site was confirmed in the adopted plan, and 2 years after the local plan examination inspector, Ms. Hockenhull, come to the view that the proposed allocation HA55 was sound, the appellant, I'm afraid, had lost confidence that the process of resolving outstanding matters in relation to its application would be drawn to a positive conclusion, or that there was any sense within the above-mentioned bodies of the momentum required to deliver housing on the appeal site starting next year, 2025, in accordance with the Council's own adopted housing trajectory. Officers gave assurances that the application was acceptable in principle, still the Council's position, but offered no firm commitment to report the application to committee, and accordingly, and with regret, the appellant formed the view that there was little or no prospect of securing a planning permission by 2025, let alone the housing completions that the local plan had intended by that time, unless it was prepared to roll over and accede to requests for contributions which, frankly, it knew did not meet the tests of Reg 122. And while surrendering to these demands might ultimately have delivered a planning permission, that permission would itself then be vulnerable to challenge by judicial review if it was granted on the basis of payments which were not capable of objective justification. Now, the appellant is especially mindful that the appeal process is not to be abused. However, it already feels vindicated in its decision, in that the exchanges which have taken place since the making of the appeal have suggested the imposition of a far greater level of discipline than was previously apparent, and a willingness at last on the part of the public bodies concerned to accept some responsibility for justifying in detail and by reference to up-to-date evidence the nature and scale of the requests being made of the appellant. And by way of examples, it's only since the submission of the appeal that the local planning authority has reached a final view on the impact of the proposed development on the SPAs and concluded that all impacts would be satisfactorily mitigated by the comprehensive and extensive package of measures proposed by the appellant and integral to the scheme, such that yet further payments towards off-site mitigation strategies are not warranted or objectively justifiable. It is only since the lodging of the appeal that the local education authority has properly undertaken an examination of available secondary school capacity and determined that it did not in fact require almost £10 million to expand a secondary school when schools much closer to the appeal site have available spaces and falling school rolls. It is only through this appeal process that certain highway improvement schemes have been found not to meet the SIL tests, such that continuing requests for funding or contributions are no longer being pursued by the relevant bodies. And quite remarkably, it appears that only through this appeal process did the ICB learn of the location of the new resident population relative to existing healthcare facilities and change its approach accordingly. But we are now considering the fourth iteration of the ICB's ask for funds. It is not a productive use of these short open exhibitions to examine further the water which has flown under the bridge. Suffice it to say that these areas alone, the ones I've mentioned to you, ma'am, in paragraphs 8 to 11 above, amounted to very substantial financial obligations that were being required without proper justification to burden the proposed development. Moreover, as my focus turns to the current phase of the appeal process, the appellant would readily acknowledge that a sense of momentum has at last returned and that productive discussions are currently ongoing. Some of this has been very late in the day, and only last Wednesday did we receive, for the first time, the specification for the proposed primary school. These matters are still under review, and the midnight oil is being burned by the appellant's team to try to ensure that any outstanding differences can be resolved or at least narrowed, and that it is in a position to explain coherently to the inquiry, to you, ma'am, and ultimately to the Secretary of State, the basis for any disagreement. Ma'am, can I just add here, it's because of this late speeding up of exchanges that myself and Mr. Shadravian have endorsed to you the programme that involves, as it were, an initial topic-based session, an opportunity to return to any matters that appear outstanding on Thursday of this week, and then a final opportunity to deal with any detailed drafting matters next Tuesday. And we hope that you find that acceptable and indeed helpful in all the circumstances. The main ongoing point of disagreement between the appellant and the local planning authority relates to the significance of the fact that the appeal development is to be subject to a sill levy, which will generate the payment of approximately £10 million to the council. This decision was made by the local planning authority in the face of the clear recommendation by the sill examiner, Mr. Keith Holland, that the appeal development should not be subject to sill. The LPA has justified its sill to the public on the basis of a wide range of projects, including, for example, strategic highway improvements and leisure facilities with a borough-wide role. The appellant has been proactive and always willing to accept liabilities to deliver or pay for highways works which are directly necessary to mitigate the impact of its development. However, it is not content to pay very substantial contributions towards or completely to underwrite where the local planning authority has failed to gather any other contributions from other recently consented development, remote schemes which may have a borough-wide advantage, benefit, but where the Regulation 122 nexus is either extremely flimsy or non-existent. Several of these schemes have been identified by Ms. Baker, the appellant's highways expert, as precisely the type of strategic highway improvements which the LPA must have contemplated when drawing up its sill proposals. However, the local planning authority appears to take the view that with the repeal of Regulation 123, it is a free agent and can do whatever it likes with the £10 million sill pot, which it will be scooping from the appeal development. It has plunged, for example, vast resources into a theatre project and appears to be of the view that it can divert as great a proportion of sill monies as it desires to that project, irrespective of the basis upon which its sill was set and ultimately approved. The respective positions will be tested during the inquiry, but the appellant is firmly of the view, one, that the local planning authority cannot reasonably promote a sill charge on one basis and then ignore it once it has obtained the powers to levy sill. Two, that it should not be paying twice for projects which are acknowledged to be strategic or borough-wide infrastructure. And three, that the prospective existence of a major sill payment by a development is ultimately relevant to the detailed application of Regulation 122 to proposed planning obligations. That's all I say at this stage, but rather like Mr. Shadravian, I'll return to this as necessary in closing submissions when we've seen how the evidential land lies. However, ma'am, even if you were not to accept the appellant's approach, this would not be fatal to the appeal scheme. The planning obligation will, in each case, provide for multiple outcomes, so that where matters remain unresolved at the close of the inquiry, there will be an obligation in place which will deliver what you, ma'am, and the Secretary of State ultimately determines will comply with Regulation 122 of the sill regs. In conclusion, at this stage, both principal parties agree that the outcome of this process should be that a planning permission will be issued, subject to a set of planning conditions and obligations which will comply with the relevant statutory and policy tests. As I understand the position, learned friend has confirmed this, neither party is contending that an outcome could be dismissal of the appeal, at least on either of the cases that it is promoting before you, ma'am. And just by way of footnote to that sentence, the extra care issue flagged by Mr. Jupp in his main proof can now be resolved on the basis mentioned to me this morning, which we are obviously going to explain to you, ma'am, during the course of the next few days. On this basis, the balance exercise, the balance exercise does not appear to arise, and the debate at this inquiry should be confined to whether the evidence supports the appellant's or the local planning authority's positions in relation to the proper application of Regulation 122 to each of the proposed planning obligations. Thank you, ma'am. Unless there's anything further than I can assist you with at this early stage, those are my short opening remarks.
Mr. Hill. Going to move on now and hear from the interested parties that wish to address the inquiry. So, Marshall, if you'd like to come up, and if you turn the microphone on, it should go green. Okay. Thank you.
Ma'am, just so I'm clear about how we proceed with interested parties, are we in inquiry mode or in round table mode now, so that will I, if necessary, be offered the opportunity to ask any of the interested parties any questions I may have, or is that something that you're not going to offer in this case?
I think if you've got questions directly as to what Mr. Marshall has to put before the inquiry in this document, it would be appropriate to ask him now if he's happy to answer them.
I'm not saying I do have any, ma'am, but I'm just trying to clear that matter up before we start.
But I would also remind you he's a lay witness.
Absolutely, and it won't be a matter of cross-examining Mr. Marshall, but if anything crops up in what is a new document, then there may be some clarification.
But I think that's perfectly reasonable. You're happy with that, Mr. Marshall?
Yes, quite happy with that, Mum.
Thank you. So whenever you're ready, I'll tell.
Thank you all. Well, my name is Robert Marshall, and I'm speaking now on behalf of the Fareham Society as a member of its executive committee. I have their authority to speak on their behalf. And just to give a bit of a background to the society, it was established in 1976. It has about 800 members. It was a long-held preference of the Fareham Society for this site in the strategic gap to remain free of development. However, as the site has been allocated for housing in the local plan, we have to accept that no in-principle objection can be raised on the application the subject of this appeal. And we recognise that the proposed development will provide a significant part of the council's required housing land supply. However, we do have a number of detailed concerns on the nature of the proposed development and in relation to the lack of agreement between the council and the appellant on contributions to important infrastructure essential to make the development acceptable in planning terms. The former were made in our letters to the council, and I've given the dates there, and the latter observations were made in a deputation to the planning committee. So the concerns we have on the detailed nature of the application, first of all, on the impact on the strategic gap. Although this is an outline application with all matters bar access reserved, it is accompanied by an illustrative master plan, which is clearly indicated to form a basis for more detailed development of the site. It is therefore important that at this stage we make observations on that plan. Given the important role the strategic gap has in this area in the separation of settlements, it is important that its role is recognised in the development of this site. In certain respects, as we've outlined in one of our letters, that would be so. However, we're concerned that the building heights parameters plan
shows an area west of the proposed sports hub and on the site's southern boundary with the strategic gap as having houses 2.5 stories high. Dwellings of this height would be potentially an unacceptable intrusion upon the gap. The master plan accompanying the local plan placed this housing area in a wider LE4 site, which gave the possibility of two-storey houses in this part of the site, which would have had a lesser impact on the gap. We recognise the potential benefits of having the open space for the school and the sports hub in the southern part of the site to reduce the development's impact on the gap. However, it's important to ensure that these open areas should not have the tall and intrusive fencing and lighting that can sometimes be the case. This will be a matter that will benefit from being subject to reference in the master plan. The Society is pleased that the land to the west of Peak Lane does not constitute land to be developed for housing. It will remain, therefore, an important part of the strategic gap. As such, it should be retained as an unspoilt field and copse with only grass paths to provide access. Hogging paths, viewing areas, seating and interpretation signs, etc., would introduce a degree of urbanisation that would harm the open, undeveloped appearance of the area and the strategic gap. The submitted land use parameters plan should be annotated to this effect. It is accepted that the gap between the proposed houses and the southern boundary of the application site, which remains the heart of the strategic gap, may of necessity have some hogging paths and suds, ponds, etc. However, any such features in this area would have to be limited and designed in such a way as to retain an open, undeveloped appearance. Again, the submitted land use parameters plan should be annotated to this effect. And finally, on a detail point in relation to the application, and that's on the change that was made to the proposed vehicular accesses onto Peak Lane and Longfield Avenue fairly late on this stage of the plan. We consider that the free flow of traffic along Peak Lane and Longfield Avenue is best served by roundabout junctions as set out in the local plan master plan, rather than the junctions now proposed. Roundabout junctions as initially proposed will also ease egress from the site. It is conceded that with vehicular access onto Peak Lane being in the local plan master plan, it cannot be required to be deleted, as we had actually suggested in the previous letter. We accept that can't be done. Now, on the matter of provision of services and financial contributions, which is the key matter between the two parties. Time and again, one of the major objections the Fareham Society sees being raised on residential housing developments is the inadequate highway infrastructure, education provision and health provision to service them. It is therefore of concern that on this major housing scheme, that the necessity for these facilities and services or the means of contributing towards them is being contested. On healthcare, the Fareham Society has considered from the outset that on-site provision to meet the health demands arising from development of the scale proposed should be met on site. Given the undue pressure already placed on existing surgeries, we are most concerned that the ICB says that this cannot be achieved. And there, just see the committee's council reports reference. This is an unacceptable state of affairs made even more regrettable by the likely absence of an acceptable alternative. For from the evidence of the parties, it seems that the Fareham Health Centre is the only one with the possibility of enabling additional floor space to be provided, and yet without agreement from the ICB and the Health Centre to expand its catchment area boundary, it seems that this would not provide a viable solution. As we have stated in our written submissions to the Planning Inspectorate, this an extraordinary position may have arisen where it would be unacceptable to grant planning permission on a site allocated for development in a local plan. Now, just turning to education, Ma'am, I've indicated secondary provision. I have a paragraph in there. Can you please strike that out from the evidence? I've no wish to provide that as evidence, given the clear indication from the parties on their belief on the acceptability of secondary school provision. And I'm very happy to provide an amended an amended statement on my behalf with that struck out, so that when that is for you and then provided to the Secretary of State, that's
I
taken
think
out.
would be helpful if you could just substitute it before we,
I'm more than
later in the week.
more than happy to do that, Mum. I'll bring it later in the week.
Thank you.
So we turn to primary provision. The variation between the council and the appellant on determining the required contributions are noted, and I have to acknowledge the society and myself had no expertise on this. We simply note that A, it is essential that the necessary level of contribution is provided, given the constraints on local authority expenditure, and B, that it will place that the society will place greater weight on the evidence of the local education authority than an appellant likely to have an understandable interest in minimising costs. Finally, on off-site highway infrastructure, development of the scale proposed will place an additional strain on many parts of the existing highway network. A reliance on sill payments would seem to be unwise, given Mr. Jupp's evidence in paragraph 470 of his proof that it is for the LPA to choose what infrastructure to spend sill on. Better, therefore, to rely on Section 106 contributions, where money received must go to mitigate the impact of the proposed development. Whereas in this case, there has been disagreement on the level of contributions, or maybe even whether they should be provided, we will merely ask that through this appeal, this matter is most rigorously investigated. Thank you, Mark.
Right. So it's just on your first page where you're talking about the impact on the strategic gap and the height of the dwellings at 2.5 stories. Where, in terms of, I've got the master plan open, so it's probably not got everything I need to see on it. Where do you feel that would be visible from, noticeable, the extra half story?
You would see that from within the strategic gap, bearing in mind that the strategic gap lies directly south of that housing. So the strategic gap boundary has actually been drawn up, as I understand it, to go right up to the housing boundary. I accept that from some more distant viewpoints, there will be a restrictive view of it. Certainly in the summer months when there's vegetation on the hedgerows to the south, it would be restricted. Whether that would be quite the same case in the winter months when that vegetation was removed is maybe a matter of doubt. But primarily, I think from the area directly south of the housing development.
So does that include where the primary school and other infrastructure is, or
Yes. I mean, it's a little bit difficult sometimes looking at the local plan, but it seems to me as though the strategic gap does actually cover those areas. That the areas that have been excluded from the strategic gap are solely or primarily the areas where housing is being proposed.
And is the I can see we've got the Stubbington bypass there. So from south of the Stubbington bypass as well, it would be noticeable. Is that what you're suggesting?
No, I think that from south of the Stubbington bypass, or even from on the Stubbington bypass, it may be too distant to have any significant effect, and certainly there will be screening from trees and so on that lie to the north of the bypass.
Thank you. That's the only point I wanted to clarify with you. Mr. Hill, do you have anything?
I don't think there's anything I need to ask Mr. Marshall in terms of clarification. I mean, there are a few points that we could helpfully make, but I think the best thing to do is to follow the suggestion in the draft programme, that we hear what the interested parties have said. And I'm going to ask if you'll permit me, Mr. Jones, just to deal with a few evidential points by way of response to help and explain what the appellant's position is. I don't think cross-examination is a helpful way forward at this stage.
Thank you. So, is Councillor Hare, please? Thank you, Mr. Marshall.
Thank you, ma'am. Thank you for allowing me to speak. I'm Councillor Hare. I represent Stubbington Ward and also the division of Crofton, so Stubbington, Fareham and Hillhead. Whilst HA 55 is in Fareham's local plan, it does not mean that this must be built on. The proposed housing development on land south of Longfield Avenue in Stubbington should not go ahead due to its impacts on the local environment, infrastructure and community well-being. This area is one of the few remaining green spaces. Oh, apologies, sorry, am I speaking too fast? Okay, yeah, so. Okay, of course, thank you. Shall I start again? Okay, thank you. So this area is one of the few remaining green spaces, providing a habitat for local wildlife and offering residents a place for recreation and tranquility. Development would increase traffic in the area, counteracting the recent improvements in air quality and reduce congestion following the opening of the bypass. Local infrastructure, including roads, schools, and healthcare services, will struggle to accommodate the additional population, potentially leading to overcrowding and a decline in service quality. Additionally, the loss of this open space could diminish Stubbington's charm and sense of community, which residents value. Preserving this area is crucial for maintaining both environmental health and the quality of life in Stubbington. So that's my way of introduction to my speak. Highways and traffic and roads. It's very disappointing just when traffic problems are solved to alleviate traffic, developers seize the opportunity for selfish gain at the expense of residents. The Stubbington bypass was built to provide better traffic movement from the Gosport Peninsula and provide easy access to Daedalus, which is now known as Solent Airport, whilst alleviating traffic from Stubbington Village. Since the bypass opened, Stubbington has experienced a decrease in traffic, allowing residents to enjoy a quieter, cleaner environment with a reduction in traffic, resulting in better mental health, less stress and anxiety. If allowed, this development would add significant traffic, resulting in a waste of taxpayers' £42 million spent on the bypass. With the average household owning 2 vehicles, that's roughly 2,000 additional vehicles congesting Longfield Avenue, Newgate Lane, Peak Lane, Gosport Lane, Maze Lane, Titchfield Road and Stubbington Village. So these are the roads that could be affected or would be affected. The impact will also be horrendous at the Market Quay roundabout in Fareham, which already suffers from queuing traffic, creating more pollution, just when this area has passed the acceptable level of pollution. Vehicles are often parked on both sides of Longfield Avenue East. With more traffic using the road, congestion will worsen, creating a bottleneck at the proposed junction E on the plans, accessing the site, which will be unsafe. Vehicles travelling east are likely to create bottlenecks on Newgate Lane, which was recently redesigned to ease traffic flow. This increase in congestion would also impact the Market Quay roundabout under the bridge, causing further delays. Vehicles travelling west to join the A27 will likely use Rowan Way, which is already used as a rat run. Near the junction with Ramvilles Lane, Rowan Way has a sharp, narrow bend that poses safety risks. Alternatively, drivers may opt for the top of Peak Lane with the junction with the avenue, where the avenue is controlled by traffic lights that are already congested during peak times. The stretch of Peak Lane from the bypass to the Longfield Avenue roundabout currently has a 50-mile-per-hour speed limit. The addition of a new junction on this road would raise significant safety concerns for vehicles merging into fast-moving traffic. A development of 200 properties is already underway on Oakcroft Lane, along with another 99 near Brookers Field, and additional planned housing at the old barracks in Leon Solent. These projects will increase traffic on Stubbington Lane, putting additional strain on the roundabouts in Stubbington Village. So I'm talking about the planned housing at Leon Solent that would cause traffic on Stubbington Lane, which additionally then would go through Stubbington. This development fails to meet policy TIN2 on highway safety and road network from the local plan, which states that development will only be permitted if it poses no unacceptable impact on highway safety and does not create a severe cumulative, apologies, I cannot say the word, impact on the roads. That word is very important, ma'am, because it's important that with all these developments, there's more traffic being created. Hampshire County Council is already facing budget challenges and cannot afford the necessary highway improvements to support this development. Additionally, Section 106 and SIL payments fall short of covering the upgrades needed to ensure road safety. Furthermore, residents are actually very fed up with traffic and with highways works continuing. When the Stubbington roundabout, ma'am, was being built, residents were, they had lots of problems getting to and from work, from schools, shopping. Once that was complete, we were relieved that, okay, highway works is finished. And now, with these more developments, further problems will occur. Schools. I was going to say this, but at the last minute, I understand that Hampshire has agreed, or there's been talks with Hampshire that there will be no funding required for senior schools. I have this morning, since I found out last night actually, I have emailed the director to ask when this was agreed and why this has all happened. So the document, the previous document addresses school provisions for the development, noting that Crofton schools in Stubbington nearly at capacity. Any contributions agreed upon may become outdated by the expansion projects that are undertaken due to inflationary pressures. Although they're saying there's no funding required, I believe there will be. By the way, figures quoted in the documents previous are from Q4 2021. The documents that were in the plan from the developers. The evidence, yes. Yes, that was before they have spoken to Hampshire. I believe the appellants had a last-minute chat with Hampshire or discussion with Hampshire, but I'm wondering why they didn't speak to Hampshire a long time ago. So given the size of the development, why wasn't there earlier and longer engagement with Hampshire County Council? This has been a last-minute engagement. With the SEND provision where the cost per pupil for providing a special school place exceeds that of mainstream pupil, the bill to accommodate SEND provision 4 times that of the mainstream. So the reason I talk about the SEND is the school that is being provided does not have SEND provision. Bearing in mind that the education and healthcare plans have increased. 10 years ago, there were 4,000. In Hampshire now there's 14,000 or just above. Apologies, I don't have the correct figures in front of me, but that's roughly the amount. So I would like to know why these aren't considered properly by the developer, although again, at the last minute, they're saying that there will be provisions. So I'd like to have further reassurance and evidence how they're going to be provided for.
In terms of what you want me to take away from your comments on this scheme,
Yeah,
so in terms of education, you're asking why you're accepting there is agreement, but why was it not made earlier?
Yes.
Is that correct? And in terms of special needs education, it's the point that the number of children with special needs statements has increased greatly, but I'm not sure what the point that follows on from that is.
So what I'm trying to say,
what the scheme's meant to do is mitigate the impact of any children with such needs within the scheme.
yes, my point being is, where is there extra provision being provided for children with special education needs? Where will they go? Where will the money be spent? And I, ma'am, am a governor at a special needs school within my division. And I do know the capacity is 160, but they cater for 193 students. And with moderate learning difficulties, how is it possible to accommodate more children? So where will that money go, and how much are they prepared to give? Because again, as I said, SEND provision is 4 times that of the mainstream students. Does that make sense? Sorry, a little bit. It was a bit confusing there.
No, I follow you now.
Thank you. One of the other points that wasn't made in the opening submission was sewage. The existing infrastructure is already struggling to handle sewage management. Adding 1,200 more houses, a school, an 80-bed care home and a community centre would overwhelm the system. So imagine an additional 3,000 to 4,000 people flushing toilets, taking showers, gunk from washing machines and dishwashers, cleaning cars, etc. So without increasing capacity, rainwater and surface water will flood the pipes. The existing infrastructure is already inadequate and needs replacement before any such development can occur. In the recent development at Oakcroft Lane, the developer reportedly agreed to a £2 million payment to Southern Water to increase capacity for around 200 houses, but no improvements have been made. The existing infrastructure is still being used, and there are already sewage-related problems on Marks Tay Road behind the development. All the sewage and water will be directed to Peel Common Waterworks. How will it manage with this application for 1,200 houses, plus 200 in Oakcroft, 99 near Brookersfield, and all of Wellbourne, which is 6,000 houses? Peel Common Waterworks already has a foul smell. Mum, in Stubbington, you can smell, depending on the direction of the wind, you can smell the foul smell coming from the sewage works. Our coastline is already full of sewage. We do not want more building that will increase sewage into the Solent and people's homes. This should be expanded before any permission is granted for any more large developments. Again, we need to look at the cumulative impact. The NHS broken in Stubbington and the surrounding areas. Stubbington has been crying out for a new medical centre, and more GPs, as well as Titchfield and Highlands Road. With Oakcroft Chase being built and soon 99 more homes on the other side of Newgate Lane, where will these residents go for their medical needs? I read in the first 144 pages of the master plan document, the developer agrees there is lack of medical care in the area. So why does this planning application propose just a health centre to meet the needs of potentially 4,000 people? We do not need another health centre because we already want to have one of those in Fareham. What we need is a medical centre with GPs. Primary care is broken, QA is broken. When this is fixed, we can develop, not the other way around. So basically, ma'am, we need the infrastructure first before we can give planning permission for a large development. Housing, ma'am, there is already a 68-bed care home provision being built on Stubbington Lane. So I'm not sure whether we actually need an 80-bed care home. The developer is including the sheltered accommodation in its 40% allocation. That's the 80-bed care home. I don't think this meets the provision of 40% affordable housing. Affordable properties and rent is what is needed. We need to know the definition of affordable in this proposal, since affordable for one person may not be affordable for another. Ma'am, I'm also concerned, I should have said this when I was talking about schools. I am concerned about safe walking and cycling to school. I don't think it's been thought out properly, and the 24,000 for school cycle upgrade is really not enough. I'm not sure if the developer has been to see the schools. Crofton School in my area, where some of these children will most probably be going, has lots of children who cycle to school, and school cycling parking area is always completely full. So my concern is the safety of the children travelling from this development through the rights of way or through the paths, where in the winter days where it gets dark early, that will these children be safe to travel from the development through to Crofton School? So inclusion, ma'am, I mean, there's lots more I can say, but I'll just call it a day here, and we'll go through when you go through the inquiry. We need to bear that with the town centre generation, there is a possibility for provision for affordable housing, which is what Fareham truly needs, not a massive development that will significantly encroach on a strategic gap. And also, in this strategic gap, there's deer roaming freely on that stretch of land. It's the birds of prey and wildlife's natural corridor. The land can be used for sustainable farming and can help drainage. Careful land management can offset clean air for the current communities. Thank you, ma'am.
Can I just clarify, at the beginning, you said that you know it's allocated by HA 55, but that shouldn't go ahead. So you're saying that although it's allocated in the local plan, that doesn't mean it's an acceptable development?
Yes.
Okay. And then could you, are you able to email perhaps what you were reading?
Yes, I will do it
If you
properly and send
emailed
you an email.
to
Rachel.
the council officer maybe, or Ms Dyson at the planning inspectorate, either would do. And then it will be added to the website. Are we able to update the website maybe at lunchtime? Yeah, thank you. That would be helpful. Okay, so thank you for your time.
Thank you.
So, sorry, Mr Hill, I didn't ask you if you had any questions.
Ma'am, I think I've just a couple, if you don't mind. They're really just clarification. Councillor, thank you. Am I right that you are a Fareham councillor rather than a Hampshire County councillor, or are you both?
I'm both.
You're both.
Yes.
You are both. So in relation to your role at Fareham, I mean, you say that the developer has seen the opportunity for selfish gain. This is a site allocated by Fareham Council in its plan and a larger strategic allocation in that plan, isn't it? This isn't a speculative development.
No, I understand that. It is on the local plan, but doesn't necessarily mean that it needs to go ahead. If the infrastructure is not there,
Yeah.
infrastructure is the problem.
Yes, I'm just trying to understand that the point that you made about this being an opportunity for selfish developer gain. It can seem to square with your council's allocation of the site in the plan for development. But we'll come to the infrastructure points later in the week, so I'm not going to trouble you with those. Only in relation to your role as a Hampshire County Councillor. It's right, isn't it, that in relation to all the matters that you raised in relation to highways, Hampshire County Council is not objecting in principle to this proposal, is it, on highways grounds?
Hampshire County Council doesn't always get it right.
Well, that may be one point, but Hampshire County Council isn't objecting in principle to this proposal, is it, on highways and transportation grounds?
But Hampshire's I'm sure Hampshire have said that if there's enough SIL and Section 106 provisions,
right,
then it could
right.
possibly go ahead.
Thank you. So, I mean, you just made quite a lot of detailed points about the highways, and those would have been issues that would the county council's highways experts would have been aware of, wouldn't they? They have a role in assessing the details of the development, and the points that you've raised about junctions or links that are under pressure are matters of which they would be aware.
They would be aware.
Yeah, thank you. Thank you very much, ma'am. Those are the only questions.
Thank you. Thank you. It's 11:35, so I'm going to suggest we take a short break and return at 10 to 12 and hear the other interested parties. And then is Mr. Goodman available this morning?
He is.
He is. If we could do him before lunch, I think it would be helpful, but we'll see how we progress. Okay, so if we can return at 10 to 12. Thank you. Can the next councillor that wishes to speak come forward, please? When you're ready, if you turn the microphone on.
Thank you, Mum. Doing a little bit of background to the developer. Since 2020, the developer has been submitting plans for approval. At first, this was not part of our local plan, but before it was finalised, the number of houses were increased for the area and therefore the land was included. So that has been an updated thing. The 2021 population census has never been considered. And if it had been, it probably wouldn't have been included in the local plan. In July 2022, alongside the two MPs for the area, Suella Braverman and Caroline Dinage, we held a public meeting in order to halt the development and to take it to the Secretary of State. At the meeting, it was unanimously agreed that it should be halted. Infrastructure was the main objection. Since then, it has sat on the Secretary of State's desk. The developer earlier in the year negotiated a discount on the SIL payments after trying not to pay any. In August, after the general election, they have taken it to yourselves, Mum, clearly wanting a quick answer and not prepared to wait for the new government to decide how they are going to fix the housing crisis that this country is faced with. The officers have worked very hard to agree all the outstanding points, but as yet are not finalised. And I do feel it's very unfair on Fareham Borough Council that they have been blamed for dragging their heels on this. They couldn't make any decision because it was sat on the Secretary of State's desk, and that was down to us as a...
Sorry, can I ask you what you mean by sat on the Secretary of State's desk? I thought the application was with the council.
It was, we wrote to them and they had it sat on their desk that it had to go back to the Secretary of State before it was approved. That's my understanding of it. There's a letter written in October 2022 that said, I've got this letter and it's going to be halted until I sign it off. That was my understanding.
Okay, I'll ask one of the parties to clarify that. Thank you.
I feel that this has been very much rushed through. I would like to keep it on the desk until Fareham Borough Council is able to look at the wider picture of trying to meet the housing needs. The strategic gap is important, and if it is to be built on, then let's build social houses that tick the boxes for all of our residents. In 2019, the bill for bed and breakfast was £200,000 for Fareham Borough Council. Last year, it was £2 million. As a local council, we need social housing, not 1,200 houses to make the bigger profit for the landowner and developer. We are in a housing crisis. As a council, 6,000 homes are being built in the north of Wales. You can't say that we're not doing our bit. Locally, there are 230 houses being built in Stubbington. These houses are not selling because they are not affordable and not wanted. However, the following also need to be addressed before we can start building on this site. The sewage is a problem, and I do think that that probably needs to be added to your list, Mum. It's not able to cope now. We have sewage going into the Solent. They do tick the box every time, Southern Water, to say, yes, we can cope, but putting sewage into the Solent is not the way to cope. It's all going to go to the Pill Common Treatment Plant, which was built in 1979 and has not really been developed since then. This should be expanded before any planning permission is granted for any more large developments. Southern Water keep saying they can cope. Clearly, they keep taking their bonuses and are liars, one of the worst performers in the country. The NHS is broken in Stubbington and the surrounding area. Stubbington needs a new medical centre, and it's been talked about for the last 30 years, and more GPs, as well as Titchfield and Highlands Road. Trying to get an appointment is absolutely impossible. My husband has this week tried to and was unsuccessful. There is just a health centre proposed for potentially 4,000 people. It's still in process of being, and Oakcroft potential 1,000 people is still in the process of being built, and primary care is broken. QA is just broken and financially the third worst trust in England. When it's fixed, we can develop, not the other way round. Time for a change. The NHS say no, developer wants to throw 7,000. That's an insult to the local population, not even 7 GPs for a year. For housing, the developer has included sheltered accommodation and it's 40% of allocation. Social rents are what is needed. As a council, we should choose what is being built in our precious strategic gap, not the developer. The roads, the junctions with more traffic lights is too near the bypass junction. 2,000 more cars are going to cause more queues and traffic pollution, especially at the Newgate Lane end of Longfield Avenue, which has just passed an acceptable level of pollution. Putting a cycle path along the edge of St Michael's Grove is not an option. I don't even like going down there in a car. We are by the coast. We don't have the option of south. It's 180 degrees to get out, not the 360 of a normal place. The roads are not going to be able to cope. Hampshire highways are not fit for purpose. They gave the green light to a housing development in Fareham. The Housing Association built 200 houses and they are now standing empty because the access that they granted was not fit enough. So now they're saying the access can't be given and the 200 houses sat empty. The schools I will leave to my colleague. The new government said that they would fix the NHS and stop sewage pollution. Unfortunately, the two can't be solved together. For a change, let's fix Pilcommon to deal with the extra housing and have a medical centre fit for the 21st century, along with primary care that the system can deal with. Stubbington all needs a community centre improved. The shower block is something out of the 1950s. If this development gets the green light, then the inspectors should be held accountable for the Solent being turned into a cesspit and residents dying because they cannot get to see a GP, let alone attain a hospital appointment. Thank you, ma'am.
I've got no questions to ask of the councillor, ma'am, but as I said, there are a few points, factual points that Mr. Jones would like to come back at the end of the third parties in accordance with the programme.
That's it, I've not pressed hard enough. My name is Anne Richards. I was formerly a community nurse for Portsmouth Health Trust, Fareham and Gosport. I used to work 5 till midnight, covering out of hours emergency calls. When we first started on the community, there were 2 teams, one for Fareham and one for Gosport, one trained nurse and one support care worker. Through attrition of staff, that was reduced to one trained staff and one support care worker. We covered every surgery from Moody's Boatyard to Paul's Grove, everything in between, down to Portsmouth Harbour and throughout Stubbington. Some nights we worked regularly and at a decent pace. Other nights we worked from 5 o'clock till 2 o'clock in the morning without a break, answering calls from patients who've been waiting all day for district nurses or a medical opinion. I can only say that I speak to you from the aspect of health because that's where my experience lies. The proposed development will without doubt exert even further pressure on multiple services that are already stretched to capacity. Those pressures exist because it's almost impossible to provide adequate staffing levels to meet the demands of the ever-increasing population of Stubbington and the surrounding areas caused by developments such as this. Schools, GP surgeries, pharmacies, hospitals, district nursing and social care services struggle daily to deal with the constant pressures. The stress caused by these continued pressures acts like the ripples in a pond and spreads throughout the community, because when one person is stressed, it impacts on those around them. It impacts on a person's interactions with family, friends, neighbours, work and work colleagues, and acts as a silent killer pulling everyone down. The increasing number of housing developments is not without consequences. Roads and motorways have become even more congested, and travelling in any direction is a nightmare. Noise, environmental pollution have impact on the individual and the local community, adding unremitting stress. People have chosen to live and invest in areas such as Stubbington because they're less exposed to those consequences of overdevelopment and the impact it can have on their health. As part of studies for a degree in health, I examined the sociology, psychology and biology of health and illness, and in particular the relationship between stress and illness. Continued stress exerted by sociological factors such as overdevelopment impacts on the person's psychology, which impacts negatively on the person's biology, resulting in a decline in health as the immune system becomes exhausted, disease and illness follow, and placing even more demands on stretched services. The size of this development means that there will be constant and long-term road disruption caused by heavy plant coming and going from the site on roads that were not built to take such treatment. This will add to the stress of local residents living close to and those passing through the area, and will also cause traffic disruption to minor roads as people try to avoid the area. Many developments like the one opposite B&Q resemble military barracks and add nothing to the area, but house people like battery hens crammed into small boxes. As a community nurse, I've visited patients in these so-called apartments. There's very little storage, no privacy, and no sanctuary to escape the noise of TV and neighbours. It's obviously debilitating and adds to stress. When nursing students ask me how I knew what to do and what nursing strategies to employ, I would tell them to put themselves in the other person's position and ask myself how they felt and what they would like to happen. Please put yourselves in the position of local residents and make the same judgment when deciding on this and future developments. As I've said before, a healthy community is a happy community.
I don't have any questions of Ms. Richards, which is a good job. I think that might be the last of the parties who indicated.
Is there anyone else who wishes to address the inquiry who didn't say so previously? No? Okay, thank you.
In that case, what I was going to ask was if we could just turn to Mr. Jones, who I know wanted just to clarify a few points that came up during the course of those 4 submissions. Not plunging headlong into the evidence, but just picking up on a few points of clarification around things like the building heights parameters plan, holding direction, and
Do I need his proof? Or?
I don't think you do need his proof. We'll just work our way through the 4 submissions. It won't take longer than 5 or 10 minutes, I wouldn't think. So are you content that Mr. Jones just remains sitting on my right here?
I think so.
Yeah, and I will just introduce the points, as it were, as we go through. The first being in response to Mr. Marshall. I think there were just a few points about the strategic gap, the building heights, that you wanted to respond on in relation to Mr. Marshall. Mr. Jones.
Thank you. Good morning, Mum. Just dealing with the issue of building heights firstly, there is a reference in the statement of common ground, paragraph 313. Which essentially explains the relationship between the building heights plan and Appendix D.
Lots of statements of common ground. This is the main planning one, I think.
It's at CD 5.4, but I've also noticed it's in a group called D.
Uh,
3.3.
The foot,
Oh, sorry.
should be at the foot of page 3 now.
So essentially there, Mum, you have an explanation of Appendix D and its context in relation to character areas, density and building heights. And because the design code, which HA 55 refers to, is anchored effectively by Appendix D, those parameters are seen to supersede the building heights parameter plan. So when reserve matters come to be determined in relation to that part of the site Mr. Marshall was concerned about, they will be determined pursuant to a design code that reflects parameters in Appendix D. Mr. Marshall also talked about the parkland features, effectively along the southern edge of the development north of Tanner's Lane. I have addressed that in paragraph 616 of my proof of evidence. We don't need to turn it up, but it essentially says that the character of that part of the appeal site will change. So whilst it is land that is still subject to the strategic gap designation, its appearance will be materially different from that which one observes presently, and which will continue to be the character south of Tanner's Lane.
So we just turn to a few points on Councillor Hare's submissions, which covered a wide range of issues, some of which we're going to come back to in this afternoon in relation to highways and traffic. But there are one or two other points that aren't currently on the agenda, such as sewage. Do you want to just touch on those points that we won't be coming to this afternoon?
There is a suite of consultation responses within the core document library. CD 12.1 and CD 12.5 are the consultation responses from Southern Water. The first of those is January 2020. Sorry, the first of those is from 2020. The second is from January 2024. And that more recent response, so far as foul water is concerned, wastewater is concerned, effectively refers back to the 2020 response and says that there are no matters in relation to capacity. So the statutory undertaker in their response to the planning application is content the surface water can be, that foul water can be satisfactorily accommodated.
That's it. Thanks, then. And then in that case, just come on to Councillor Needham and anything arising from that. The reference to a holding direction, a letter by the Secretary of State. Have you ever seen such a letter?
I haven't seen the holding direction issued from the department to the local authority, nor have I seen any correspondence that precipitated that. So I haven't seen the request for the application to be called in.
Councillor Needham also made a point about what was needed was affordable housing, social rents, etc., not market housing. Could you just remind the inspector how the appellant has approached the request for the affordable housing provision on the site?
The appellant's proposal accords with the relevant development plan policy. It provides 40% affordable housing.
In terms of health and air quality in particular, can you just remind us how air quality has been dealt with?
Again, the statement of common ground, paragraph 4.43, records the evidence from the environmental statement as regards a negligible effect on air quality.
And in terms of the relationship of that issue to highways, has there been any suggestion that the Stubbington bypass is at capacity? Problem with that?
Not that I'm aware of, no.
Thank you very much. Is there anything else that you needed to come back on at this stage, Mr. James, or were those the only points?
Not at this stage. Thank you.
Thank you, ma'am.
So I think if we move on and hear from Mr. Goodman,
I'm very much in your hands, ma'am, as to how we deal with this. Obviously, there is a proof of evidence and appendices. I don't know whether you've already formed your views on anything you'd like to ask Mr. Goodman. He does have a short summary and conclusion section 10 at the end of the proof, pages 33 to 36, which covers most of the ground. And I could invite him to read that through so as to allow others who are interested to follow it, or we could just take the entire document as read. I'm, as I say, very much in your hands.
I think it would be helpful if he went through that first. And then
He's certainly prepared to do that, ma'am, and I've warned him that might be the best way of approaching this material, which is fairly detailed, and as you know, is the product of a very lengthy period of assessment going back to about a decade, I think. So, Mr. Goodman, can I just introduce you, please, to the inquiry? Do you have all your materials open in front of you now? I can see lots of post-it notes that look a bit perilous there, but hopefully they'll stay in place.
Stuck on.
Are you Kurt David Goodman?
Yes, I am.
And are you a senior director of ecology at FPCR Environment and Design?
Yes.
Good. And if we look at page 4 of your proof of evidence, we can see that you hold an honours degree in environmental biology from the University of Sunderland and an MSc in environmental management, conservation and recreation from Sheffield Hallam University. You're a member of the Chartered Institute of Ecology and Environmental Management, and you have over 25 years experience of complex developments. Is that correct?
Yes, that's correct.
You and your practice have been involved in consideration of the ecological matters in relation to this site for some many years, and that's included various survey work and devising and agreeing a strategy to mitigate any impacts to the relevant areas of ecology. Is that correct?
That's correct.
Your proof of evidence covers the relevant legislation, policy, guidance, responses from consultees, consideration of biodiversity net gain, and then we come at the end of the document to a discussion of the council's final response on this issue. And as we know, there is no outstanding issue between Fareham Council and the appellant in relation to these matters. But I think it would be useful if you took us nonetheless to section 10, which is entitled Executive Summary and Conclusions, on page 33 of the proof, and just take us through that paragraph by paragraph so that others who haven't had the opportunity to read it can be appraised of at least the summary of the contents.
Yes.
And just read away. And I'm not going to interrupt you unless I feel there's an imperative need to do so.
There we go. The site has been subject to detailed ecology survey work and ecological assessments, including the submission of an environmental statement and addenda and shadow habitat regulations assessment. These detailed assessments have been subject to extensive consultation with Fareham Borough Council and other statutory and non-statutory consultees. During the protracted determination period, both Fareham Borough Council and Hampshire County Council have concluded that, with the provision of the mitigation measures outlined within the various technical submissions from an ecological perspective, the appeal proposals are acceptable, and that the development would not result in significant adverse effects to biodiversity or statutory designated sites. The officer's report to committee confirms that there are no putative reasons to refusal of the application relating to ecology, and Fareham Borough Council's statement to case CD 5.3 submitted for this appeal does not present any ecological concerns, but concludes the development of the site is acceptable from an ecological perspective. In addition to the above, the proposals benefit from examination by the local plan inspector, where the inspector found that the allocation underpinning the proposals was acceptable. The site is situated within the zone of influence of several European designated sites, including the Solent SPA and the New Forest SAC. Due to Natural England's position, and despite the views of the local plan inspector, Fareham Borough Council and Hampshire County Council, the effects of the development on these designated sites is a matter requiring consideration by the inspector at this appeal. These matters do not include direct effects to the integrity of either of the designated sites from land take. Technical assessments completed by the appellant and the council for the local plan concluded potential effects to air quality and nutrient neutrality would not affect the integrity of the conservation objectives of these designated sites. Natural England raised no objections to the proposals on these grounds. It is important to note that the nutrient neutrality mitigation strategy completed by the appellant confirms that the mitigation package would result in significant reduction in nitrates equivalent to 500.57 kilograms total nitrogen per year entering the Solent SPA. In my view, this is a significant benefit of the proposals and one which could support the delivery of other allocated sites in the local plan. This ensures compliance with local plan policy NE4. As discussed in my evidence, detailed ecological surveys over an extended period, 2013 to 2024, have not recorded any qualifying bird species from the Solent using the site. Small numbers of golden plover and snipe, which are part of the wider wildfowl assemblage of the SPA, have been occasionally recorded using the site. From this data, the site has been identified as providing supporting habitat for SPA birds, but following the guidance provided in the SWBG strategy, the site has been recorded as a low use site. The proposals provide significant mitigation for the loss of supporting habitat. This mitigation includes the provision of a dedicated 10-hectare bird reserve area on land west of Peak Lane. Section 7, paragraphs 7.3 to 7.5 and 7.17 to 7.21 of my evidence provide details of the proposed mitigation, and Section D provides the management principles for the reserve. The provision and long-term management of the reserve will provide optimal overwintering resources for SPA bird species assemblage. With the application of this mitigation, it is my view that this mitigation avoids effects to the Solent SPA, both alone and in combination with other plans or projects, and the integrity of the conservation objectives of the Solent SPA are maintained. Natural England agree that the mitigation is adequate to maintain the integrity of the Solent SPA, and this view is shared by Fareham Borough Council and Hampshire County Council. Thus, the proposal comply with the requirements of the Habitat Regulations and Local Plan Policy NE5. The outstanding issue raised by Natural England to designated sites is the potential in combination effects of increased recreational pressure to the Solent and New Forest, with their recommendations for financial contributions towards the relevant site-specific mitigation strategies. Given the actual travel distance between the site and the New Forest, an examination of the evidence that supported the zone of influence with regard to recreational visits by residents from Fareham, it is my view that likely significant effects to this designation should have been screened out prior to the appropriate assessment stage. However, given the extensive mitigation package provided on site for recreational pressures, it is my view that screening such effects into the AA, which is the appropriate assessment norm, makes no material difference, and these effects have been fully assessed in the AA. Section 7, paragraphs 7.23 to 7.25 provide the details of the overall mitigation package to avoid alone and in combination effects arising from increased recreational pressure from the site proposals. The green infrastructure provided within the scheme exceeds Natural England's standard SANG requirements, providing the equivalent of 12.97 hectares per thousand population. It is my view that the provision of this mitigation avoids potential effects to the integrity of the designated sites, both alone and in combination with other plans or projects. This view is supported through the local plan, which does not require the provision of such extensive open space. Rather, local plan policy NE3 suggests proposals can either pay the relevant strategic contribution or provide bespoke mitigation. as outlined in my evidence, and in respect of the site, local plan policy HA 55, the inspector also concluded that the mitigation provisions should avoid the potential effects of increased recreational pressure on both designated sites. This view is shared by Fareham Borough Council and Hampshire County Council. Given the evidence, it is my conclusion that the mitigation package is adequate to avoid effects to the conservation objectives of both designated sites without further contributions, and it is consistent with the requirements of the Conservation of Habitats and Species Regulations 2017 as amended, and also local plan policies NE1 and NE3. Again, this opinion is shared by Fareham Borough Council and Hampshire County Council. In relation to other matters relating to ecology and nature conservation, the dominant habitat present across the site is intensively managed arable land. This does not provide a significant resource to biodiversity locally and is of negligible ecological importance. The completed survey work confirmed that other habitats present across the site, including the grasslands, scrub, ditches, were not of significant ecological value. The important ecological features included the off-site Oxley's coppice and the boundary hedgerows. Oxley's coppice is adjacent to the site boundary. To maintain its ecological value, a 30-metre buffer is applied around the woodland. The proposals provide additional scrub/woodland edge planting. This planting has the benefit of reducing recreational pressures on the woodland and providing ecological enhancements through the creation of a diverse woodland edge. With the application of this mitigation, it is Natural England's opinion that the proposals will not affect the conservation status of the woodland, and it is my view that the mitigation will result in long-term positive effects to the condition of the woodland, as recreational activities are likely to be concentrated within the bookends on either side of the bird reserve. The proposals have maximised the retention of boundary hedgerows and provided significant additional hedgerow planting across the scheme. This will result in positive effects to biodiversity locally, but will also promote connectivity for fauna. Development of the site will inevitably result in the loss of existing habitats, but this loss is largely restricted to habitats of low and negligible ecological value, comprising mainly arable land. The overall mitigation package outlined demonstrates the proposals will provide a diverse range of habitats across the site. Once mature, these will provide overall gains to biodiversity are demonstrated through the use of the static metric. This shows gains in habitat units in excess of 40% and linear units exceeding 10%. Section 8 and Appendix A of my evidence outline those further. As the proposal have maximised retention of ecologically important features and will provide significant net gains to biodiversity, they are compliant with the requirements of paragraph 180D, 180C, 186 of A of the MPPF, December 23, local plan policies NE2 and NE6. The proposals also comply with the requirements of biodiversity net gain as detailed in Part 6 of the Environment Act 2021. The bird reserve also fully mitigates the loss of arable land to the east of Peak Lane, allowing the creation of more favourable habitats with a management regime which will ensure the long-term resource for breeding birds and in particular for skylarks. In my view, the extent of habitats and their management will result in positive effects for the wider bird assemblages, and with specific reference to skylarks, Natural England confirmed that the level of mitigation is adequate. The small population of reptiles recorded is not a significant ecological constraint. With the application of the mitigation outlined in my evidence, including the application of precautionary working methods prior to works, the proposals will not affect the conservation status of the species locally, and the proposals will satisfy the requirements of the Wildlife and Countryside Act 1981 as amended. No statutory ecological constraints to development have been identified from the presence of a bat roost. The completed survey work did identify bats using the site for the purposes of foraging and commuting. The recording assemblages were generally dominated by common and widespread species. The green infrastructure improvements around the site will ensure that the linkages are retained, but the creation of new habitats will increase foraging, which will result in overall positive effects to the local bat population. A small population of water vole has been identified on land west of Peak Lane. This is not affected by the proposals, and its presence has not been identified as a statutory constraint to development. But the enhancements proposed by the development are likely to result in positive effects for this population. The detailed ecological survey did not record significant use from other protected and notable species, and the presence of such species has not been identified as an ecological constraint to the development. The proposed enhancements detailed in the evidence above, however, provide enhancements for species recorded on the site and provide suitable habitats for new species to occupy. These measures will be beneficial for local biodiversity. In summary, the site has provided a bespoke green infrastructure that fully mitigates the effects to the proposed ecological receptors, ranging from over provision of recreational opportunities beyond the recognised standards such as SANGs, and the creation of a 10-hectare bird reserve area, which will not only mitigate for loss of supporting habitats, but provides betterment for other bird assemblage and other fauna. Such detailed mitigation avoids any likely significant effects or effects to integrity of the designated sites in the zone of influence surrounding the site. Accordingly, the proposals comply with the requirements of the habitat regulations. Given this, it is my opinion that and that of the local planning inspector, Fareham Borough Council and Hampshire County Council, that the inspector's appropriate assessment can be positively concluded. In relation to other matters, the proposals will not result in the loss or deterioration of irreplaceable habitats as defined in the NPPF. The proposals have provided significant mitigation and compensation for the loss of habitats within the site, which will result in the delivery of net gains to biodiversity. The proposals have also fully mitigated the potential effects on protected and notable species. Therefore, from the submitted information and the evidence presented herein, I conclude that the proposed development proposals are in accordance with the requirements of the Conservation of Habitats and Species Regulations 2017 as amended, the Wildlife and Countryside Act 1981 as amended, national and local planning policies.
Ma'am, I know that the witness is very happy to answer any questions you might have, or indeed produce any additional note that you might find to be of assistance in your reporting.
Thank you. I'm just going to start by looking at the two issues of difference with Natural England. And then I've got a few points I want to clarify. So in terms of the New Forest SPA, as I understand it, Natural England's concern is that if you take a straight line, you're within the zone of influence. But the practical solution is, because you've got to go around the estuary, I think I don't know if it's got a title, but you can't. It's a much longer journey. I've got 35 kilometres. I've read somewhere. So it's quite a journey. It's not a local trip, and that's essentially the difference between you on that one. Is that correct?
That's correct, ma'am. It's our opinion, not only that of a distance matter, but from the perspective of the green infrastructure that we've provided, that the green infrastructure will accommodate for our not only our developments, recreational needs, but that of the local area.
Why was Fareham included? Because all of Fareham would need to, or most of Fareham would need to make a similar journey, wouldn't they?
In terms of from Natural England's perspective, it's a little bit odd, I have to say, that the inclusion of Fareham into the overall recreational impacts to the New Forest, because the actual supporting evidence by footprint ecology excluded Fareham from potential recreational impacts to the New Forest.
If you made the mitigation payment that Natural England is seeking for the New Forest, what's it likely to be used for? Have you any idea?
On the New Forest?
Or is it not sought? So I need to find can somebody point me to the shadow habitats assessment? I did have it. It's one of the original applications.
Our shadow habitat regulations assessment.
Sorry?
Our shadow habitat regulations, ma'am.
Yes.
And it's the updated versions at CD 2.45.
2.45, thank you. That's right. So in terms of the New Forest, in order to address Natural England's objection, and I understand your position is it's not a reasonable objection, and I think the council takes the same view, they would be seeking a financial payment in terms of recreational disturbance. Is that correct?
Yes, ma'am.
So that payment would it be used for wardens or, I mean, the New Forest isn't like, it's different to some other areas, isn't it? It's quite, a lot of the land is open, isn't it?
Ma'am, in terms of the details of their recreational mitigation strategy, I haven't got those to hand, but the way that I understand it is some of it will go to wardens, and other monies will go to the upkeep and maintenance of footpaths and other infrastructure within the New Forest itself.
Thank you. So the other area is the Solent SPA, SAC. As I understand it, your case is that, and it's the council's in agreement, and you've referenced the local plan inspector, that that the recreational disturbance payment's not required because you're over providing to such an extent in terms of green infrastructure and alternative space. Is that correct?
Yes, ma'am.
If I was to agree with Natural England, I can't see a mechanism in the unilateral undertaking or the conditions that would allow the payment to be made. Whereas for a lot of other, is this outside your scope?
It's that's beyond my scope.
Right, that's
I
fine.
haven't been involved.
So the point, just for later in the inquiry, if I were to agree with Natural England, how do we resolve that? Because I can't see it in the.
No, ma'am, you're absolutely right. And if I can just chip in, if it's helpful to do so, it was one of those areas where we thought we'll just see how this session goes, and if you flag that up as an issue that you'd like to have provided for, of course the position changes in a way now that the appeal's been recovered, and perhaps one can't necessarily predict how the Secretary of State might view these matters. I think out of an abundance of caution, although we are very firmly of the view that it would be a surprising decision to trigger those payments, we probably do need to have a schedule in there that provides, as the other matters are provided for in the alternative, so that if you were to recommend to the Secretary of State, or the Secretary of State were to take the view independently of your recommendation that these payments ought to be made, there was a mechanism to deliver that. At the moment, you're quite correct, that isn't provided for, but we will turn our attention back to that.
So we could return to that later in the week. I've got a couple of questions there. So probably, Mr. Goodman, in terms of this issue, what would be the route to the Solent? Would most people go by car, or is it walking, cycling, easy cycling distance?
From our side, it's more likely to be a walking route. I would have imagined that they would.
I'm sorry, I think the microphone's probably not.
Sorry. From our side, it would be more of a walking resource that our local residents are likely to visit the Solent from, but there are car parking areas along the coast of which one could drive to and get out at for a walk. You could do, it would be a fair trek.
So your thought is most people will probably drive and use, if they were going there, they'd drive and use the car parks that exist.
I'd have thought so, ma'am, but I'm not we haven't done detailed studies to look at that for this particular development at this particular location.
Thank you. So the other points that I just want to clarify with you really arise from the UU and the conditions. So they might not be for you today, and just say so if that's the case. So looking at the unilateral undertaking, Schedule 2, I think that's the bird protection measures, and I've got no questions on there. I do, apologies. So on there at 4.1, and it's talking about the on-site routes. I think the schedule. So that's the open space in the bird reserves. Is there any conflict that you're aware of between providing these on-site routes and any ecology issues?
No, the on-site routes around the bird mitigation area have been agreed with the with Natural England through the overall process, and mitigation has been put around the bird reserve area to avoid potential conflicts in that respect.
Sorry, they relate to the conditions. And it's just really references in that there's a reference to Oxley's Meadow, which I'm assuming will be near Oxley's Copse. I just don't know. Is there a particular plan I should be looking at? And it's the same issue on the Linear Park and Newlands Meadow. So if you can't point me to them now, could somebody provide me with a plan and show me where they are? I think you're probably all very familiar with them because you've been talking about them, but I'm struggling to find them. I'm sure they're there somewhere.
If I can interject as a sort of more informal in this arrangement. Well, I've raised the point when going through the condition because I couldn't work out where these meadows were as well. I think I know where they are. There was reference in one of the conditions in the design and access statement, but I don't think it's in there. I think it's in one of the landscaping plans. But we tend to amend in those, I think there's 3 conditions, something like 10, 11 and 12. So it's made clearer for anybody who doesn't know exactly where they are, whether it's reference to a separate plan or whatever, we will amend those conditions to help you on that point.
I think that's important, and it's important in the future for enforceability.
Yeah, it is, yeah.
The individuals here aren't.
Yes, ma'am. Thank you.
Yeah, thank you. So it goes again, it's picked up at condition 14 about the management and the enhancement. There's areas, slightly different approach. So I suppose the final point is, there's 2 other points. One is about the issue about providing some of the public rights of way that are proposed and whether you feel there's any conflict there with the SPAs or whether that's a matter for this afternoon. I'll be led by Mr. Hill.
I think we'll deal with that this afternoon, in relation to the public rights of way. I think there might be agreement between ourselves and for the council on that, the borough council on that. But we can come back to that. I don't know whether there's anything further that Mr. Goodman wants to add on that.
No, not in relation to public rights of way.
Okay, and then it is the final point. There's a condition seeking an arboricultural. Oh, sorry, not at the moment. Okay,
Okay.
I'll come back to you later. Sorry, there's a condition requiring an arboricultural impact assessment. I'm not sure what's actually been done already, but from looking at aerial photographs, etc., it seems like most of the trees, we've got Oxley's copse, and most other trees are on the boundaries within hedgerows and things. Would that be correct?
That's my understanding.
Very much so.
Okay. Thank you. So that's what I wanted to ask you. Mr. Hill, is there anything further that you want to come back on?
I don't think there is, ma'am. I've provided you with clarification, I hope, in relation to the planning obligation. We will ensure that that is added in as a further schedule. I think there will be a further plan provided to identify the meadows that have been referred to by name, but not necessarily picked up on an easily accessible plan that would run with the conditions. So we'll ensure that's dealt with. I don't think there's anything else that I need to trouble you with now. Thank you.
Yeah. So, Mr. Millard, is it something that's appropriate to what we're talking about now?
Yes, please.
I think it would be easier if you sat at a microphone so somebody can hear you. So all I'm doing at the moment is clarifying Mr. Goodman's evidence.
Yes, of course, yeah.
And right, okay. Yes, let me turn mine off.
Thank you, Inspector. My name's Philip Millard. I am the Countryside Planning Manager for the Hampshire County Council Countryside Service. You raised a number of bits in your evidence relating to the fact that agreement with Hampshire County Council. That is not true in all circumstances, particularly from the Countryside Services perspective. So our role as a service is to manage countryside sites for Hampshire County Council, which includes Titchfield Nature Reserve, National Nature Reserve, which is the SPA in question, as well as the carrying out the statutory duties of the Highway Authority in regards to the public rights of way network. So you made reference to various policies, including policy NE3 of the local plan. The argument I've made is within the evidence. I'm not going to recite that particularly. Our case in relation to recreation.
I'm not sure that this is the right point for this. I thought you were just going to clarify a
Okay,
particular
no,
point,
that's what.
but we can hear you this afternoon.
Okay, well, I can explain the New Forest issue in regards to recreation.
Okay.
And why it's relevant, and also in regards to the damage and harm that will be caused to the SPA as the on-site mitigation isn't sufficient.
I think we'll hear this. We'll return to it later today.
Yeah, by all means.
I thought it was just a point on Mr. Goodman's
Yeah.
evidence.
Yeah.
Is Mr.
I'm just confused. I don't recall seeing any ecological proof of evidence from Mr. Millard. I think his contribution was confined to public rights of way. So I would be most unhappy if a lot of new material were led on the first day of the inquiry when we've had proper inquiry procedures rules in place to allow the exchange of evidence in an orderly way.
Mr. Millard, I have a proof of evidence from you on the rights of way, so that's probably, and there hasn't been any challenge before to Mr. Goodman's evidence that he submitted. Okay, thank you. Right. So it's coming up to 1 o'clock, so I suggest we take a break. Mr. Sorry.
That's all right. I have difficulties with it sometimes
think about it.
Can I just indicate how I intend to proceed this afternoon? Bearing in mind, this is a round table discussion and is intended to aid our understanding and also aid resolution so far as possible. What I'm going to do is introduce Ms. Ballerin and then ask her to make some introductory points to contextualize what she then has to say about the individual junctions, items A, B, and the Ds, by reference to a plan which will be on the overhead. It introduces nothing new, just simply sets out where these things are, so members of the public can understand what's being said in relation to what item. And also to update the inquiry as to the latest position of the local highway authority in relation to those mitigations. In terms of the timing of those mitigations, and also by reference to matters arising in the rebuttal evidence of both sides. But I'm trying to keep it as simple as possible. So subject to that, that's going to be the extent of my intervention, just to guide focus, essentially.
Thank you.
Also, can you stay where we are?
Yes, yes, I think that makes sense.
Then that enables us, because third doesn't describe it.
Mm.
It enables us then third, it needs
I'm entirely happy with that.
So we'll resume again at 2 o'clock. Okay. Thank you. Could I remind the people that are going to email in their submissions to do so, please? Is everybody ready? Thank you. So the inquiry is resumed. We're going to look at the highway issues this afternoon. So you said you would introduce.
I will indeed, Mum, if you're ready to begin.
Just before.
Oh, yes, of course.
I did just say to Melody Froman, there's one matter just to put on your radar, as it were. During the course of the morning, there have been a few exchanges in relation to education matters of a positive nature, and I think there will be, or is in production, a supplementary statement of common ground, which would then just leave us, I think, with one outstanding issue to discuss tomorrow. Three points that were in dispute have been resolved. So I'm encouraging the relevant parties to get that signed off and circulated so that you can have it before the end of the day, and then it would affect perhaps your preparation for tomorrow when we're going to come to education.
Thank you.
But I think there are some documents that might be coming in as well, but I'll leave Melody Friend to introduce those.
So I've been passed one document, a plan showing the junction.
Yes.
Such that plan.
This plan, which is actually on the overhead. And the reason for producing this, there's nothing controversial about it at all. It just simply shows the junctions and routes for improvement for both capacity and active travel measures. And we thought it would be of assistance to the inquiry and to members of the public to see which junctions it is we're talking about. And not least because there is something of an interrelationship between them as well, a functional relationship which we need to address briefly. So I'll introduce my witness. You are Valerie Ballerin, or Ballerin, depending upon which accent you want to.
Either.
And you have a Master of Science degree in Transport Planning and Engineering from the Institute of Transport Studies, University of Leeds, and a member of the Chartered Institute of Highways and Transportation, etc. It's all set out in your main proof of evidence. And you are undoubtedly aware of your duty to the inspector in the context of even this and a roundtable discussion. Now, what I want to do is to address a couple of issues with you from the outset before looking at the specific requirements for the junctions or the routes as we proceed. Now, the rebuttal evidence from both sides has been very helpful, and I say that that's uncontroversial. We're helping as much as we can, but it did raise a few issues which I know you would want to address from the outset in relation to the core documentation for the highways assessment, and also the question of modal shift or modal change. So if you'd like to just preface what we're going to say in relation to the various junctions with that, I'd be grateful.
Turn this on. I was just going to run through the a summary, if you like, of the approach taken by Hampshire County Council as the local highway authority in determining the site-specific impacts of the development on the local transport networks in accordance with paragraph 57 of NPPF. And that's fully detailed in my proof of evidence, so I do not propose to run through this again. But since the production of both the proof and rebuttals, we have had ongoing discussions with the appellants, and that kind of so what I would like to do is provide a summary when we come on to discussing each of the mitigation as to where we are with those discussions. I'm going to summarise the local highway authority's current position and then discuss each mitigation in turn. And I will do that in terms of need and significance of impacts, first of all, and then talk about the contribution values and or costs for each of the mitigations. And finally, and the mechanism for contributions. And by that, I mean whether it's section 278 or to be delivered via planning obligation at section 106. And then finally, we'll talk about triggers, which is what this plan on the screen is actually referring to. The issue of whether contributions will come from SIL or section 106 will be addressed by Mr. Jupp. So I'm only concerned really with providing evidence of whether the impacts and therefore the mitigations meet the SIL tests. I'd like to start with some clarification in respect of the authorship of, if that's the word, of the STA, the Strategic Transport Assessment, and the Strategic Transport Assessment Addendum that were put together for the local plan, in support of the local plan. Both the STA and the STA Addendums were commissioned by Fareham Borough Council, but were produced by Hampshire's Highway Services, which is a consultancy arm of the county. So not by, I think, just to make the distinctions, not by the actual local highway authority. While Sistra owns and manages the strategic traffic model, the SRTM. The report's methodology and assessments were undertaken in discussions with both highway authorities, and that's both Hampshire County Council, but also National Highways. And the local highway authority is supportive of the policies and recommendations of the STA and the local plan, insofar as they align with its LTP4 vision. However, the specific views expressed at the local plan examination in public in respect of policy HA55 do not necessarily reflect those of the LHA in specific reference to this application. As referred in paragraph 426 of the STA addendum, changes to the site allocations have been included in the model, that's the SRTM, but are not assessed individually. The growth in the model is cumulative. The impacts of each individual site would be assessed through transport assessments related to the planning application for each site as it comes forward. So there was always an intention that separate site-specific transport assessments would obviously accompany every planning applications. As we know, the local plan allocations and the proposals put forward in each applications may differ to some degree.
Right.
So the methodology used to identify impact thresholds.
Sorry, just before you go a little bit further.
Yeah.
When you talk about the strategic roads and highway network,
yeah,
what is that referring to? Because often it refers to the A roads, and that's national highways.
Yes, that's right. Yes. So this,
you're clearly not referring to the A.
No. So obviously Hampshire County Council is looking primarily and solely to the local road network. But obviously the STA did cover the strategic road network, which is the responsibility of national highways.
So when in the evidence, I've come across the reference to strategic highways, or
yes,
that's not. It seems to me that is something that comes under the jurisdiction of Hampshire, or not?
Not always. The A27 does, but the M27, for instance, and the routes leading to the M27, obviously.
So the A27, Hampshire's responsible for.
Yes.
Right.
And the junctions.
Right. Okay. Okay.
The methodology used to identify impact thresholds and appropriate mitigations is fully detailed in the STA and STA addendum. National highways in particular required traffic impacts to be identified based on predict and provide worst case scenario of development within the local plan as assessed within the SRTM. As a strategic model, the SRTM underpins the outcome of the STA in terms of vehicle delays and queues, but does not quantify the wider impacts of other measures, primarily those to active travel modes. Again, the limitations of the SRTM are fully explored in my proof of evidence, but in summary, only routes leading to and including the strategic road network would be subject to highway capacity improvements and reassessment as part of the do something SRTM model scenario. All other infrastructure mitigations identified in the STA and IDP relate to the need to reduce demand and or affect mode share. In terms of infrastructure improvements identified at various locations that were shown to experience a severe or significant impact on the network, focus was given to works on active travel routes and or necessary to maintain acceptable and reliable levels of public transport services. So there's a distinction, obviously, between the SRTM, which has provided the assessments in terms of vehicular traffic impacts, but obviously does not fully refer or provides any additional information and couldn't be modelled insofar as active travel measures or public transport measures, other than obviously if a bus lane was incorporated on the network that could be modelled, but passenger numbers, etc., wasn't. As with the local plan STA, Hampshire County Council's policy of achieving the objective of LTP4 is to promote and enhance active travel use, and that has been a determining factor in considering appropriate mitigation for this development. Assessment of impact significance for these active travel modes is not based on highway capacity impacts, but is based on in terms of adequacy and availability of safe routes from the site to various destinations, starting with routes to schools as a priority, followed by local facilities and services including but not limited to Fareham Town Centre and Station as per policy HA55. Where alternative routes and or existing infrastructure are available, Hampshire County Council has considered whether these would remain adequate for accommodating the development as a whole. In terms of defining appropriate triggers, it is the local highway authority's view that affecting change at the onset is a key element to addressing the LTP4 objectives and vision. However, Hampshire County Council is amenable to compromises in terms of trigger of the various elements of the mitigation package on the basis of bringing forward those active travel elements of the package.
The policy foundation for this, both in the local plan and elsewhere, is that capacity improvements should be, as it were, last resort.
Yes, sorry, I was coming on to that. Yeah,
that's okay. I'm just edging you there, yes. Because one of the criticisms, as it were, from Ms. Baker, is that you've not taken sufficient account of modal change or shift in terms of sustainable travel.
Yes.
What do you say about that?
So highway capacity improvements are a last resort, and they tend to be, the impact tend to be defined using the traditional method of predict and provide. There are limitations to the SRTM, as I hinted earlier, which is recognised in both the STA and during the determination of the applications, which is what has led Hampshire County Council to request a site-specific assessment of development impacts in line with the recommendations from the STA. There would have been an alternative to consider the development impacts of policy HA55 to be cumulative and simply asked for contributions towards all IDP transport measures, but the approach that the Highway Authority has taken is very much to one of site-specific impact and site-specific related impacts in terms of traffic and transport.
All right, thank you very much. Now I want to move on, please, to the plan itself.
Yes.
So I'm going to take these in order. Some of them are going to be grouped because of the interrelationship between them. And you understand why when you think you through it. I think probably, however, we ought not to ignore those which are agreed.
Correct, yes.
So let's begin with A1.
A1. A1 is improvements to the Ranvilles Lane and A27 junction improvements. And that's essentially just to provide additional capacity to accommodate the development traffic. And I think this is agreed, as is the mechanism for delivering the works, which are to do by via section 278 agreement.
So it's agreed. So,
yes.
So what is the impact on A1 from the development, and how would you describe that junction as part of the overall network?
The impact at that of the development traffic at that junction is obviously has been shown to be unacceptable and resulting to residual impacts in terms of highway capacity, hence the need for the mitigation. And this is the first point of access, it should be noted, onto the corridor, which is obviously the A27, which then leads on through other junctions that have been identified in the STA.
So that's the first junction reached from occupiers of the development.
Yes.
In motorised transport, heading in which direction?
Heading west, and in this instance, we're talking about the vast majority would be commuting traffic, heading for the motorway network. Yeah.
Okay, so in relation then to B2, B3 and B4.
So B2, B3 and B4 are in a similar approach to A1. The development traffic we accept that at these locations will be a cumulative impact because the junctions are currently suffering from some levels of congestion. But the residual impact was still deemed to be severe to require some level of mitigations. The mitigations that were identified came from the SRTM modelling and were listed in the IDP as appropriate. What we have done is conducted a further assessment which seeks to apportion the level of traffic as a ratio, if you like, of the likely traffic from this development, from policy HA55, but routing through those junctions in comparisons with other local plan allocations. At this point, I'd like to make clear that the SRTM, as I said before, has assessed the cumulative impacts of all the local plan allocations, but it doesn't identify specific site impacts, which is why additional assessments were undertaken.
And what did that assessment share in relation to the impact on B2?
So in relation to B2, the assessments showed additional development to contribute to an unacceptable levels of impact in terms of highway capacity. Effectively, it would push through 155 vehicles per hour during the morning peak and 151 vehicles per hour in the evening peak, which is considered a significant amount of traffic.
In terms of the MPPF test, what do you say about the degree of impact?
The degree of impact is, although there is a high level of background traffic, the existing layouts in their current arrangements could not accommodate this additional level of traffic without worsening the junction capacity. So without the mitigations, we would have a severe impact. Residual.
Do we know how that severe impact manifests itself?
It manifests in additional queues and delays at various approaches to the junction.
Are they set out?
Yes. They're set out in, I think, quite clearly in Ms. Baker's proof of evidence and rebuttal, I think. I would have to ask her for the references. But I do have, for instance, in the morning peak hour, on the approach southeast circular, the queue, taking a step back, in the baseline, during the AM peak, the junction performs over capacity with a degree of saturations by which this is measured over 100%. The southeast circulatory, the B3334 and Titchfield Hill ahead and west circulatory rides do particularly suffer from capacity issues. And once the development is in place, these do remain significantly over capacity.
Where are those figures that you're reading from? Are they in your proof?
They're not specifically quoted in my proof, sorry, because Ms. Baker had already run through.
Ms. Baker's proof.
Yes, there was various tables which provide the information. Yes.
In your view, does the development traffic, as it affects that particular junction, result in a residual impact which is severe?
Yes.
And why is that? Just so the inspector has a very clear answer to what you're saying.
Because the queues and delays will worsen to an extent that is unacceptable to the Highway Authority, particularly as the A27 is also a bus route.
Ma'am, can I just check, did you want to pick up on where those figures were now, or are you content to wait until we respond to?
I'm fine to wait to respond.
Okay, B3.
B3 is it's similar to B2. So we have a junction which at present suffers from delays with a ratio of flow over capacity, which is another way of measuring, is over 106 in the morning on one approach and over 100 on another approach, St. Margaret's Lane. When the development traffic will obviously add to that congestion. And we have got figures as well for this to show by which amounts, but the impact of the development would result in a residual severe impact.
And I mean, one might suggest that B3 is quite resistant, as it were, from the development side.
Yes.
And that it could be subject to all sorts of other traffic.
Yes.
By other developments and by other sources.
Yes, so yes, that's correct. However, we have done some further analysis of the SRTM modelling, which does assign traffic from one particular area to another, called a link capacity. And we have found that obviously the traffic from these developments was continue to route through those junctions and to access the motorway network. And that's also the findings of the STA.
Perhaps afterwards we can just extract the figures. And, give the reference to the inspector.
And this applies to B4 as well.
B4.
Yes.
Same.
Yes. So A1, B1, B2, B3, B4 are all on the same corridor and effectively just provide the route between the site and access to the motorway network.
Is there anything more you want to say about the Bs?
No. No.
Turning now to the Ds.
Yes, do we want to mention C?
Oh, I'm sorry.
That's okay.
Yeah. C.
C1 is the public transport improved mitigations, and that is agreed as 3 pairs of additional bus stops, 2 of which will be on Peak Lane and one pair will be on Longfield Avenue. So that has been agreed in terms of upgrading the bus stops to include shelters. Sorry.
So, sorry, could you put the microphone on?
Sorry, I was just under the impression from previous correspondence on it that it was 1 pair on Peak Lane at the site access and upgrades to the 2 existing pairs on Longfield Avenue.
Right, okay, yep. I got that one, the one right around. Yeah, that's fine.
Could you?
Yes, yes, we will. Yes.
Just repeat that for the inspector.
Yes, so it's 2 pairs to be upgraded of bus stops on Longfield Avenue and 1 pair of bus stops upgraded on Peak Lane.
Thank you. All right. Any more on the Cs?
No.
Right, Ds.
Ds.
Now, explain the difference between Ds and Bs, please.
So the difference between Ds and Bs, all the B items relate specifically to highway capacity mitigation improvements, whilst the Ds are very much to promote active travel and ensure the suitability and safety of non-motorized users along those routes.
So again, this is by way of description.
Yeah.
I'm going to come back to discuss triggers with you on all of these after the inspector has a very clear understanding of the functionality of these various
yes
measures which are sought. So D1 then.
D1 is upgrade of the existing pedestrian cycle path along Peak Lane and some crossing works at the junction with Longfield Avenue. I would say that D1, D2, which will come along later, D1, D2, D3, D4 and D5 are seen as a package to provide a cohesive network between the site and the various areas of the town.
Okay,
yes.
That's fine. Let's take each of those in turn.
Yes.
D1.
D1.
What do we see D1 represents?
D1 represents currently the existing arrangements are not adequate to accommodate the level of demand from this development. Therefore, it requires upgrading.
Yeah, what is it? What is D1?
It's the route, the cycle path.
The cycle path.
Yes, the shared pedestrians and cycle path, yes.
And D2?
D2 is, again, similarly, there is a current provision along the southern side of Longfield Avenue. But again, this is not adequate. It's substandard compared to the latest guidelines because it's less than 3 meters in width and therefore not suitable, again, to accommodate the additional demand from this development. So ordinarily, the Highway Authority would have asked for the works to be done widening the existing arrangements. But there is a strip, as you will see on the site visit, of trees and heavy vegetation, which is, we understand, obviously needs to be preserved. And therefore, the appellant has proposed to provide a separate route sufficiently, of the sufficient width and design standards within their site boundary. So on the other side of the landscaping.
That's D2A.
That's D2A, B and C. So it will be from Longfield Avenue junction with Peak Lane and then towards the east, just short of the eastern boundary of the development.
Again, we'll come back to
we'll cut triggers. Yes.
And to what extent the appellant is willing to accept these or not, as the case may be.
Yes.
All right, so that deals with D2.
Yes.
And then we have D3.
D3.
And D5. Same
yes.
colour, and the reason for that is because the trigger is proposed to be the same for each of those.
That's correct, yes.
Now, explain their functionality, please, and their importance to you.
So these are to align with, obviously, the specific policy of policy HA 55, which requires suitable means of walking and for cycling and walking between the site, Fareham Town Centre and the station, so that's D5. And D3, where we feel the Highway Authority feels that Newgate Lane is also going to be a major attractor of trips by those modes, particularly as it's a large retail area, but also an employment area.
Mum, as a suggestion, for the purpose of site visits, you may indeed want to see these various destinations and their relationship to the site. So that's deals with D3 and D5. We've got
D4.
D4.
D4 is essentially the missing link, which is there's no facility at present, and there's only a 2-meter footway, which is separated from the carriageway by a grass verge, and there's no control crossing to cross Longfield Avenue. So D4 essentially provides a grading of the existing path to allow for cyclists, but also to reduce the severance and tie in with the development and the existing residential area.
And D5.
D5 we talked about, that's the main access to, yeah, no, that's fine.
D6.
D6, so this is safe route to schools. Our understanding is that the secondary school will be Crofton School, which is located to the south of the site. And D6 identifies various improvements again to ensure that this route to Crofton from the development site is suitable and safe for secondary pupils.
Just on that point, please, and in terms of accessibility to schools.
Yes.
It's been suggested by Ms. Baker that you've overestimated the number of non-motorised
cycling, yes.
Yeah, cycling.
Yes.
To and from school.
Yes.
Development.
So we have obtained some information from the various censuses that are being undertaken by the Education Authority. So each school within Hampshire is required to fill in a census on an annual basis, and part of that data is travel modes to that particular school. And for Crofton, it has been shown that it is 41% of children currently cycle to the school. I think this was referenced earlier by one of the third parties.
So your essential analysis in your original proof,
yes,
stands in your view, notwithstanding those points made by way of rebuttal?
That's right, yes.
Thank you. Any more to say on D6?
No.
Okay. D7.
D7. This is at the Rowan Way, Longfield Avenue, Peak Lane junction, and it's a scheme that has been identified in the LC WIP. At the moment, there's no suitable crossing or shared pedestrian cycling facilities at the roundabout. The road safety team of Hampshire has also indicated that this location is particularly unsafe for cyclists in reviewing their previous accident records and undertaking some further analysis. We are looking obviously for improvements at that locations. There is an agreed part of D1, which we talked about earlier, is actually for the appellant to provide a shared route across the northern approach of the roundabout, so to east-west corridor, which would accommodate their additional demand for pedestrians and cyclists. But in reviewing the impact at that locations in terms of traffic volumes, it's quite clear that this will carry a significant amount of vehicular traffic, which would affect existing pedestrians and cyclists, and therefore requiring that to be mitigated by the full scheme, which looks at the other approaches.
So it's cyclists generated by the development.
So cyclists generated by the development and pedestrians generated by the developments would be accommodated by the mitigations part of D1, but it's the additional traffic movements at this location which would affect the existing pedestrians and cyclists at the location.
D8.
D8. D8 is the junction of Longfield Avenue, Newgate Lane. And there are some deficiencies in the existing infrastructure. And again, these have been identified in the LC WIP at this location. The shared pedestrian cycleway at the roundabout feed into drop curbs with tactile paving on each arm, but there's no controlled crossing provisions, and pedestrians and cyclists are having to cross 2 lanes of traffic, which currently is subject to a 40 miles per hour speed limit. So again, considering that we have identified Newgate Lane, retail and employment as a important and critical area for access between the sites, and this completes, if you like, the works that are also recommended for D3 at that junction.
Okay, D10, D9.
D9.
D10.
D9 is the Gudge Heath Lane A27 junction. And again, deficiencies that have been identified through the LC WIP at these locations. The control crossing facilities for pedestrians and cyclists are limited on the A27 western arm of the junction. And there's uncontrolled crossing facilities on Redland Lane and Gudge Heath Lane, but nothing on the A27 eastern arm. Again, the mitigation here is required to address the fact that additional traffic from the development would route to that potential locations, but also that it forms part of the walking corridor for residents of the development in accessing the town centre and the rail station.
And finally, D11.
D10. D10 is improvements to the Gillies. The Gillies is currently an off-road cycling route, which links to the rail station. Again, deficiencies have been identified at these locations for cyclists and pedestrians. There's a well-used underpass, but no footway along the Gillies towards the underpath, and a lack of signage and wayfinding. So the current facilities, in our view, requires upgrading and enhancing to accommodate the additional movements from the development, specifically for access to the town centre and the station. And there's D11, sorry.
Yes, D11.
Yes. And D11 is linked to D10. And it's the link between the Gillies and the station specifically. And again, for the same reasons, it is a scheme that has been identified in the LC WIP as requiring improvements or as having deficiencies. And we view that the additional demand from this site would require improvements, contributions towards.
No, that's taken 40 minutes. I'm going to spend, I hope, no more than another 20 to 25 minutes going back, looking at triggers, contributions, and also what an apportioned approach would mean, as set out in our rebuttal proof, in case you take the view that it should be apportioned and proportionate rather than have to deal with the entirety of the junction improvement or transport measure. Right, okay, so.
Just before we do, has somebody got control of the temperature in here?
Are you cold?
It's absolutely freezing here.
We will do something about it.
Yes, we're obviously under the vent. Does anybody know how to?
We are.
Right, okay. But do continue and we'll.
Thank you.
Around it.
I'm very glad you mentioned it.
I've got a coat.
Might take you up from that.
Actually, there was an examination, both in that a friend and I were involved in it down in Bradford. And we had, I had absolutely no heating. I think it's -3 outside. So we had to do it on our overcoats.
I think we're quite there, but.
All right, then let's go back to A1.
Yes, so we're now talking about funding mechanisms,
And triggers.
and values, yes. Do we want to do triggers at the same time?
Same time.
Right, okay,
The triggers first, and
Yeah.
the explanation for the triggers will be changed on those.
yes,
And then the values and what you're requiring to be done
Yeah.
on each of them. And then what an apportioned approach would mean
okay,
where applicable. Is that all right?
yes, that's fine.
Good.
So there has been, in regards to triggers in particular, but also values and contributions, and there's been some further submissions, both in the UU, unilateral undertaking, but also between ourselves and the appellants, which obviously supersedes, if you like, various reporting, as you know, in the proof of evidence.
Certainly proves on the position so far as toll
Yes.
creation is concerned. It shows advances beyond the proofs and rebuttal proofs. So what we're going to do after this, produce a short table to show what those are, so you've got easy reference to them.
Yes.
All right, so don't worry if you missed the notes. All right, let's go.
So
A1.
A1, in terms of trigger, the position now agreed between the parties is that this would be required prior to occupations of the 601 unit. I think that's correct. Just double check. The mechanisms by which the mitigation works will be delivered will be via section 278. So obviously we have no costs attached to that, and that's also agreed with the appellant.
Okay. Right.
B2, B3, B4, essentially as mentioned before, because they are on the same corridor. The agreed position between us and the appellant is that the trigger is now been agreed of prior to occupations of the 801 unit, first unit. Is that originally we asked for 601, but we had further discussions with the appellant. My understanding was that we can come back to.
I think the position is simply that these are the latest proposals, and whilst we're not saying they're not acceptable,
Yes.
they represent a shift from the proofs and the rebuttals.
Yes.
But I think we'll have to let those sitting to my right respond line by line when we come to it.
Okay,
Yes.
that's fair enough. So we'll put it
Yes.
on the basis that it's our change of position.
Yes.
We're waiting to see what the appellant says.
Yeah, I think that's fair.
Okay, so don't talk about prospective agreement, just explain what you're requiring and why.
Can I just say that it's very much my hope that when we get to, say, Thursday, there will be some further resolution on these points, and we perhaps will be in a position to issue, as I think you indicated would be helpful, ma'am, a supplementary statement of common ground on these highways matters to bring you up to speed.
And we'll introduce that table for you, so you've got a record of what we've said here.
So my understanding was with A1, that's not in dispute between you. And it's not in the UU, it doesn't appear.
It should be the
Is it?
EU.
I've missed it then, sorry.
Yes, it's a 278, so it's not a contribution.
Right, it's under the 278, yeah.
Subject is required.
Yes, sorry.
So there needs to be a trigger for the 278 works to be started on completed. So that will either have to go into a condition or it have to go into as an obligation.
Yeah.
So as a condition, it will be negative.
I don't see, I might have missed
No,
it.
I think you're
No,
probably right.
yes.
I
If it
couldn't
goes
see
into the
anything.
Condition, it would need to be negative. Or it can go in as a positive obligation.
The schedule, I think, is schedule 7, isn't it? And it mentions highway works A1
Yeah.
in the definitions, but it doesn't seem to
We'll make sure it's possible.
to take it into the obligations.
Spot on, man. We'll look at that.
because I think that's one of my questions I had, is where works are to be delivered by 278, how are they secured?
Yes.
Thank you.
Thank you very much. So B2, B3 and B4.
B2, B3 and B4, so we're requiring contribution towards those works, and the way we have defined the level of contributions is by looking at the SRTM and the local plan allocations, because we accept that obviously the impact of this development is cumulative at those locations. During that exercise, and that's a point that we differ, I think, with the appellant, but during that exercise, we have worked out, and this is included in my proof of evidence, that how many, if you like, in terms of proportions, what the HA 55 means in terms of the likely other allocations that would put some traffic through those locations. The way the list was populated was, as I said, identified through the SRTM by looking at which routes, if you like, various areas undertake. And we have excluded, as part of our calculations, any sites below 50 units, because it's unlikely and it would not be possible for the Highway Authority in determining the site-specific improvements of those small-scale developments. They would not be able to seek contributions on that level. And we've also only included the remaining, if you like, shortfall from the local plan allocations. So some of the sites have already been given consent, and some have been developed, but they've been developed in piecemeal format. Again, meaning that the Highway Authority was not able to seek appropriate contributions towards works at those locations. So we found that for B2, we estimate that this development, or HA 55, is contributing to 80% of the traffic from the total.
Is that 80% of the
additional traffic at that location?
So you've taken out these other sites that were developed in a piecemeal manner and below 55 dwellings.
50 dwellings, yes.
50 dwellings, sorry. And so it's 80, is it 80% of the whole amount, or is it 80% of what's left when you've...
No, so it's 80% of the sites that we deem likely to generate traffic through that particular location. The breakdown and which sites have been included or considered to route through that locations is provided in appendix to my proof. Appendix.
And Vic, did you say earlier that these junctions are already over capacity?
Yes, that's right. So this is an issue of cumulative impact. Appendix A of my proof of evidence provides the calculations.
You've got calculation?
Yes.
Appendix A.
Appendix A of my proof.
Seen it online. So find it. Let me open that one maybe. Do your appendices, have they got the same colour?
Yes. It should be all in one, the same document. Yes, they're not a separate volume.
Right.
Yeah,
I've got it.
I had to keep it short.
So these are the sites that will contribute.
Yes, so if you like, the first two columns is site reference from the LTP policies, and then obviously the description of the sites. The next column represents the allocation numbers from the local plan. And actually for the moment ignore the net yields, but then we also looked at the approved quantums already against each of those sites, and then included in our calculations only the non-committed dwellings that remain. So for instance, for HA01, out of the 824 dwellings that were in the local plan, 738 have been provided consent or been built, meaning there's 86 units remaining. So the next 5 columns are then identifying which of those locations that we're talking about, so the Bs, B2, B3, B4, but also D8 and D9, same principle in terms of cumulative impact from the SRTM, which of those sites would travel through which junction.
So the
So if you take Sedgensworth, for instance, which is B3, no, B4, we've identified 3 sites from the local plan which would route traffic through that particular location. The total of those sites allocations would be 1,475, and HA55 represent 1,250. So the percentage impact at that location in terms of proportional impact is 85%, and that's how we worked out the contributions.
So it's 85% of the non-committed dwellings.
Yes.
Yeah.
So, yep. Would you like me to go on to the, so we are, so for the 3, sorry. I saw. I'm been told you're still writing, so I'll leave it.
So it's okay.
That's all right. So for B2, B3 and B4, we've identified, so B2, that the site was contributing to 80% of traffic through that location, B3, 85% of traffic through that locations, and B4, 85% as well. So looking at the likelihood of the Highway Authority being able to seek contributions from other sites, we deem that at these levels of contributory, factors, we are asking for the full cost of the mitigations as identified in the IDP. So for B2, this would mean £400,000. B3, it would be £100,000, and B4, it would be £40,000. Those are the costs that are in the IDP. Yeah.
So before we go on to an apportioned cost basis, is there anything else you want to say about the triggers for those?
The triggers, so we have, well, obviously we're still in discussions with the appellants, yes. But the highways position is that we would be amenable to a trigger of contributions being provided prior to occupations of the 801st unit for all 3, B2, B3, B4.
And what's the reason for that?
That's in recognitions that these are highway capacity improvements, and obviously they relate. Sorry. Yes, sure. Sorry, that's fine.
So we're dealing with why we pushed it back, the trigger to 801.
Yes.
801st unit.
So it's in recognitions that the improvements are related to obviously the amount of traffic from this development routing through those junctions, and clearly we deemed that 801, which I think is, if my math are correct, is two-thirds two-thirds of the development before obviously the level, if you like, of additional traffic needs to be mitigated. Again, because it's the contributions that we're asking, or albeit that we're asking for the full cost in contributions, it will be Hampshire as the highway authority that will deliver the works, and that will need to go through their gateway process.
What I meant is, what's the time frame for implementation after you receive the money?
It's good to, it takes a minimum of 3 years, but obviously if we from feasibility to completion of the works, and that's from an analysis from Hampshire County Council of various construction sites and highway schemes over the years, the last 10 years. It does require a long time, but the way the gateway process works, they will not proceed further than Gateway 2, which is detailed design, unless the funds are secured. So really, in practice, once the funds are received, they will have been able to undertake some works prior to that, but once the funds are received and confirmed, it should take another 1 year to 18 months for the works to be completed.
Thank you.
If one were to take an apportionment approach.
No, you can't hear what you're saying unless you press the microphone button.
I've been told off. Because people online can't hear me, inevitably, because I'm not going through the mic. So I apologise to those online, and will endeavour to work the microphone. If we were to take an apportioned approach, I'll come on to what that one might mean for you in practical terms, in terms of implementation. But if you're taking an apportioned approach, then what does the figure come out at?
The figure comes out, so we are asking for apportionments of 80% of 400,000. Is that what you're asking?
That's simply it,
Yes,
yeah,
yeah.
but just as a matter of evidence.
And 85% of 100,000 for B3, and 85% of 40,000 for B4.
All right. What are the practical implications of not receiving the
Full amount?
Full amount.
As I said, through the exercise that we've undertaken that came up with those figures of 80% and 85%, what this means in practice is that the Highway Authority will be unlikely to reasonably seek contributions from other developments to the local plan, and therefore it puts in jeopardy those works in future, unless they are able to find the shortfall in funding.
Right, thank you very much. Let's move away then. We said everything we need to say about the Bs.
Yes.
Let's move over to the Cs. Is there anything more to be said about those in terms of funding and triggers?
Yes, funding again has been agreed to be via section 278. And we have considered triggers and agreed that on my seat we will provide the that the appellant would be required to provide the stops at Peak Lane prior to first occupations, and the upgrade to the bus stops on Longfield Avenue prior to the 701 unit or the local centre, whichever comes first. And the reason for that is in relations to the phasing conditions of the development, as I understand it, where the appellant is looking to deliver the access of peak lanes first before the one on Longfield Avenue.
Okay. And does that deal with C1B?
Yes, C1A and C1B.
Okay, let's go on to the D.
Ds.
Let's go on to the Ds.
Yeah.
D1, please.
D1, as mentioned earlier, is the upgrade of the cycle pedestrian shared path along Peak Lane. The works have been agreed to be delivered via section 278. I'm just double checking. We originally required a trigger because taking a step back, in terms of the active travel mitigation measures, the principles that we've applied is that to affect change, we believe, and this is supported by research, that the sooner these works are implemented, obviously, the more likely they are to affect how people wish to travel between various destinations. But we have recognized that in parts, depending on how the development is being phased across, some may come forward later. In particular, if there is, so we have made a judgment in terms of where there is an existing arrangement, which has been deemed to be unsatisfactory without mitigations for the full development, but would cater for a certain amount of additional movements in the meantime, and that's how we've agreed those triggers.
Thank you very much.
So sorry, with the D1, what I would like to say is that currently Hampshire's position is minded to push back on this particular mitigation measures until prior to occupations of the 501 dwelling, for the reasons that there is an existing shared pedestrian cycle path, which would be adequate up until that point. And hopefully that would also allow other mitigation to come forward earlier.
Okay, thank you. Right, D2.
D2, this one is a little bit more complicated in terms of triggers, but because it's the path that is going to be provided within the application site boundary, it will be provided as part of the development works. So it doesn't require section 278 because it's obviously not on the public highway. Following discussions with the appellant, we have determined that their preferred means of mechanism for delivery is going to be to do this in line with the construction phasing program. So we have D2. Oh, I think the overhead has just turned itself off, but we have D2A, which is the section alongside phase 1 of the proposed development, so between Longfield Avenue and Peak Lane Junction, running east at a point which I think coincides broadly with Barton Way. Then we will have D2B, which will be the next sections across phase 2 of the development, so between Barton Way and Bishopsfield Road. And then finally, we would have D2C, which will complete the route to the eastern edge of the site application. So we have various triggers in relation to those sections, which we will provide you with some details, but quickly running through those. D2A would be required prior to first occupation. D2B, and that would also, include a link from D2 to the existing path, so obviously punching through the landscape strip, and the parallel crossing point opposite Barton Way would also be required prior to first occupation. So these are elements of that scheme. D2B would be required prior to occupations of 101 units. And the final section, D2C, would be required either delivered prior to first occupation of any dwellings in area 4 and 5, on whether the sports hub is being brought into use, or prior to 301 occupation site-wise, whichever is the soonest.
Okay, so far as delivery and funding is concerned,
yes, these ones obviously, because they are part of the development, they would be undertaken as part of the overall construction of the site.
Yeah.
So no contributions, no 278, just a condition.
that's D2A, D2B and D2C?
Correct.
Yeah, okay. So D3 then, please.
D3, which is the link between the eastern edge of the site and the junction with Newgate Lane. Yep. Along Longfield Avenue. The Highway Authority, for the reasons stated in my rebuttal proof, would like these works to be delivered via Section 278 agreements to guarantee that the works would be achieved at the appropriate time. We have provided a cost which is based on the Highway Authority delivering the works, which is set at I'm rounding the numbers, but 2.15 million. Again, the breakdown of the costs is provided in an appendix to my proof of evidence. And the latest positions, I think, from the appellant, although it's probably for them to discuss, is we'll let them.
So 2.15 million.
Correct.
And you're asking that to be done by way of Section 278, so no contribution.
No contributions, just this is what the cost of delivering it would be if the Highway Authority were to undertake the works themselves. We understand that the cost to the appellants would be significantly lower.
So if the option is only to secure, if the only option is to secure a contribution, that's the sum you would be requiring to carry out the work.
Yeah.
And if the inspector and the Secretary of State were of the view that it should be apportioned, have you come up with a figure for that?
No, because the full works would be required.
Okay. D4.
D4, which is the link on the northern side of Longfield Avenue between Barton Way and Bishopswell Road. Again, required this, I think this is agreed that this will be delivered via Section 278. Therefore, there's no cost attached to that. But the trigger, we have the Highways Authority's position is that there is no issue with this coming forward prior to occupation of 701 dwelling. But there are various sub-elements to D4, the pedestrian cycle crossings and connections that would be required prior to 101 dwellings, because these tie into the site, into the existing residential area, and to reduce severance. So this relates to,
figure, something 70, was it 770?
no, 701,
701.
yes. But some minor elements of that
Need to come sooner.
would be coming earlier, yes, to 101.
Thank you.
D5.
D5, again, this is the shared pedestrian cycle path along St. Michael's Grove, which provides connections to the town centre station. Again, for the same reasons as D3, the Highway Authority would require those works to be delivered by section 278. But should you or the Secretary of State be minded to use section 106 contributions, the cost that we would require would be £986,000. In terms of triggers, sorry.
I was just going to ask you whether or not an apportionment would apply to these works.
No, again, they're required in full.
Thank you.
In terms of the trigger for D5s, we believe that they should align with D3, as mentioned earlier, by providing the links from the site to the town centre and also to Newgate Lane with D3. So if the section 278, if the Highway Authority were to undertake, if the appellant were to undertake the works as section 278, we would require these to be before prior occupations of 201 occupations, which coordinates with D2 above, allowing access to the Newgate Lane facilities. If, on the other hand, you felt a contribution was more acceptable, payment would be required prior to first occupations to allow time for Highway Authority to deliver. So this is the trade-off that we are prepared to make with D1, where we've pushed D1 back, if you like, to enable D3 and D5 to come forward earlier.
Okay. D6.
D6. D6 is the route to school to Crofton Secondary. We require a contribution towards the works, which is actually the full costs of the works, and that cost has been identified as 517,000 rounded pounds. We did consider, I think there was a query from the appellant as to what these costs included, and the bulk of that cost is actually to widen the Stubbington bypass at the point of crossing to enable the 3-metre wide cycle crossing. And unfortunately, we cannot deliver this within the public highway or the current, curb lines, I would say. So it would require widening of the carriageway at that point, which accounts for that level of contributions.
Sorry, so the cost involves widening the carriageway, but it is in your own ownership.
So it's included in the 517,000.
And the land is in your ownership. You don't need to acquire it.
Yeah. There's no issue with those works also include some minor resurfacing further up, and the provisions of a link between the site and Tanner's Lane.
I viewed the bypass yesterday. It's relatively recent, and I think we've heard that from councillors as well. Given that this site has been anticipated for a number of years, why was the widening crossing not part
That's a fair question. I'm afraid I'm not in a position to answer that, unfortunately, not having been involved.
Okay.
Yes.
Well, if it's important for you to know the answer to that, I'll see if I can get an answer.
Yes.
if you've got that information, it would be helpful. It just seems to me like a project like that, when this hasn't come as a surprise, it's not, it's a local plan scheme, and that it would have seemed that would probably have been part of the scheme at the time.
I imagined that when the Stubbington bypass was first designed, we didn't have access to LTN 120, which is obviously where the more recent, if you like, guidelines as to appropriate crossing. But yes, we will seek an answer to that.
If I can sort of interject at this stage, as I understand it, the provision of the Stubbington bypass has been a much longer project, and this appeal site wasn't allocated until Reg 19 stage, so it came much further down through the time frame. And I think the design and everything for the Stubbington bypass had been prepared without taking this appeal site into account, because it hadn't been allocated at that stage.
And did the bypass, I'm assuming it probably required the acquisition plan to implement it, or was it all on highway land?
I would guess it required the acquisition of land.
Yeah. So, right.
Okay, where do we get to? D8, have we finished on D7?
No, well, D6. We've not talked about the triggers for D6.
D6.
Yes. So as we mentioned earlier, this is quite a high priority in terms of delivering safe routes to school. And I think the latest positions between the appellants and the Highway Authority is for contributions to be available prior to occupations of the 261st unit. That's correct. That was following the discussions we had last week, my understanding.
Again, those were discussions rather than an agreed position.
Right, yeah, no, that's fine, yes.
We're happy.
Yes.
61.
Yes. So if you wish to refer back to our original positions, we requested contributions prior to occupations of 101 units. And further contributions, so we would have to work out the apportionment for further contributions prior to occupation of any dwellings in areas 2, 3, 4 and 5, but provisions of the link through the site to Tanners Lanes required prior to 100 occupations after reaching either of the above triggers, again to give time to the Highway Authority to deliver the works. But we are prepared to change this to 261. And D7 is the LC WIP scheme at Rowan Way, Longfield Avenue, Peak Lane. So again, at the western edge of the site. We're asking for Section 106 contributions for this. And the contributions were based on a similar, if you like, a pro rata contributions that has been agreed at appeal for the recent Crofton Cemetery site. Again, provided all the references in my proof. And the figure came to £299,000.
Okay.
In terms of trigger for D7, Hampshire is looking for, again, prior to first occupation, especially as they would have to deliver the works, so for the contributions to be available prior to first occupation. But we are mindful that conditions could be used in the UU for the trigger to be reviewed, depending on obviously the phasing. So clawback figures, I would say. D8, D8 is the junction of Newgate Lane and Longfield Avenue. So it would complete, if you like, the route with D2 and D3. We're seeking Section 106 contributions. And again, in determining the proportions for this, we've undertaken the similar exercise to what we did with B2, B3, B4. So again, the way the calculations have been undertaken are in the appendix to my proof that we referred to earlier. In this case, for D8, we found that this site would contribute to 95% of traffic routing at that location. I mean, as it is literally located on the corner of the development, and therefore we would request full costs, and the full costs are £140,000. So again, if a proportional contributions was felt to be acceptable, we would ask for 95%. In terms of trigger, on D8, we originally asked for contributions to be provided prior to occupations of the 401 unit. But through discussions with the appellant, my understanding is that it is now agreed to deliver to provide the contributions prior to 261 unit occupation. Again, that was part of the discussions, not necessarily agreed, but floated as an alternative. So our positions is 401 units, but we would be prepared to make the other changes that we discussed to be able to bring this forward earlier, 261. Again, in recognitions that because this is an important link to Newgate Lane facilities.
Is Newgate Lane a cycle pedestrian route?
So that's the D3 mitigations. So it would link with that. This is at the crossings at that junction at the end of D3.
Okay.
D9, Gudge Heath Lane A27 junctions. So those are walking, cycling and public transport improvements. Again, we're requesting Section 106 contributions based along the similar methodology of D8 and the B2, B3, B4. From our calculations, we deem that this development would contribute to 88% of the traffic routing at that locations, and therefore, again, for the similar reasons to the others, we would request full cost, the full cost being 410,000.
When you say 88% of the traffic at that junction, you're talking about motorised traffic?
Yes, yes. Yes, because although the mitigation is related to active travel improvements and public transport, it's the impact of development traffic on existing users.
Next one, please.
And sorry, do we want to go through trigger? Yes. Trigger. Again, our original position was prior to occupation of 401 units. Following discussions with the appellants, we are minded to agree prior to 801 units if it allows other mitigations measure closer to the site, particularly D3, D5 and D8 to come forward earlier. D10, the improvement to the Gillies. Similar to D8 and D9, again via Section 106 contributions, and this site has been found. Well, we've calculated this site, sorry, would have a 63.16%, which I think has been agreed, and that provides a contribution of 642,000. And I do believe that that contribution has been agreed with the appellant.
Well, we'll find out.
Yeah, we'll find out.
And trigger for that.
The trigger for that. So again, the original trigger was occupation prior to 101 units. But we are minded to push this back to 261 to align with the various other developments. And the key thing here is to get D6, the route to school, delivered at the same time. D11 again. This is a 106 contributions, and the apportionment was calculated using the same methodology as D10, and I do believe that was agreed at 45.45% of this site's contributing, which means a section 106 contribution of £732,000. And in terms of trigger, this one, we would be prepared to accept the contributions coming forward prior to occupations of 401 units. Yeah.
Thank you very much. Mum, I just want to make one observation, if I may, at this stage. And it's not related to the evidence on the need for this, but the mechanisms to be employed within a Section 106 unilateral undertaking as a means of making sure that unexpended monies are returned if they're not used within a particular time. And I'm raising this now because I meant to raise it actually before. There is a drafting mechanism which can deal with this on a unilateral basis, which would require the recipient of that money to undertake, by way of consideration for its payment, to use it in a particular way, by a particular time, and to return it. And unless an undertaking is given by the recipient, in this case it would be the Local Highways Authority, then that money wouldn't be payable. So I move this now because, as between lawyers, it's something which we can discuss as a mechanism. Apart from that, Ma'am, will this be a convenient moment? We've finished our contribution. It will be convenient for you to take a break now.
I think that would be a good point for.
And if you have any queries mulling through your mind, we can address those when we return.
Spare with me if I've got anything.
We needn't deal with them now. Of course, you may want to think about it over the next few days and come back, and we're very happy to review. Yes.
Okay.
Could I just say, in anticipation of our response to that, it might be helpful for you just to have open or to have available or resume, I think it's Appendix C to the main proof of evidence on highways and transportation, which just has a schedule laid out in quite a convenient way with all of those items, their description and their status, albeit as at the date of the submission of the proof 4 weeks ago. But still, I think it's quite a helpful summary. Yes, it's Mrs. Baker's first proof, her main proof. And it's got, for example, there are parts blocked in green where all is agreed.
Okay, well, as we were going to produce a table following this, it might be as well for us not to do that, but to jointly provide a table.
I think a joint table would be more useful, and if you, where you diverge, just a comments column there.
And it could also form an appendix to the statement, amended statement from the ground.
That makes sense. I wouldn't mind the sight of it before the statement of common ground if that's delayed. But I think to have it set out quite clearly, would be better. It's better for me, but very much better if somebody else is making a decision ultimately. So one question that did come to mind, you mentioned early on in your evidence that you used predict and provide to work out the capacities. Is that Hampshire's way of doing it at the moment? Because a lot of authorities are going to decide if they provide, aren't they?
No, so the predict and provide is the way by which transport traffic assessments have been provided in the past, and obviously follow the guidelines available from Department for Transport in their planning practice guides. And what is now, so effectively what it means is we estimate the potential traffic being generated by a specific development using historical data. And that's both for the traffic generations, but also destinations, so through the census. Transport planning policy has now shifted to a more vision-led approach, and which is the approach, or decide and provide, which is the approach being taken by Hampshire County Council through their local plan LTP4, local transport plan LTP4. And basically, this now looks more towards a monitor and manage approach, which is different, if you like, to the predict and provide, because that specifically looks at traffic impacts in terms of delays and congestions and queuing, but does not take account of the impacts on active travel modes and public transport.
Thank you.
So it's the established, if you like, methodology, but the guidance for the assessment hasn't yet caught up with the updated policy.
Okay, so when you take the decide and provide approach, is it for a particular percentage of traffic from a scheme, or is?
No, so obviously because we're dealing with active travel modes, pedestrians and cyclists, as I said earlier, we're not looking at mitigations in the same way as we would for highway capacity. We're looking at the suitability and the connectivity issues, impacts, if you like, of a development towards the desire lines, likely desire lines from that development to various facilities and services. So it's not a quantified impact in the same way as the predict and provide for traffic movements.
So the traffic modelling, does that allow for modal shift and active travel?
So this is where, by the nature of the SRTM, taking that first of all, the SRTM is a strategic model. It has been improved, enhanced over the years to include changes to mode share, but primarily to public transport. It doesn't, at this point in time, make an assessment of mode share for pedestrians and cyclists. What would need to happen in terms of quantifying the impact of those measures that might have onto an increased, if you like, share by these modes would be to do scenario testing. Unfortunately, and this is quite an expensive and lengthy process to do that with a strategic model of the size of the SRTM, which is why it was not possible to do, to follow that methodology for the local plan.
Okay. Thank you. And can I just ask the appellant, on the transport assessments that underpin the ES and with the transport assessment overall, did that account for the full volume of traffic, or did it?
It did. So we used all of our capacity assessment work within there, used the SRTM flows as the basis, and no adjustment to mode share for general traffic or for our site were taken into account.
Asked.
Yeah, that's
Yes, just so it's clear, that's what we were asked to do. The implication that TA work can be accepted unless we used the methodology that the Highways Authority had required.
So can I just say that at some point in the inquiry, whether it's the highway section or planning, the framework, the draft framework that was issued, I think, I remember now, was it July, or that talks about a more vision-led approach, and whether that might have any implications. So just address that. So, I don't know if it's your transport witness or your planning witness, but I would like to have your view on that, appreciating that it is a draft document. Okay.
Understood, ma'am. We'll certainly look at that and come back to you, particularly as it's likely when the Secretary of State comes to consider your report that the framework will have moved on to have been issued in its final form.
So if we come back at 10 to 5 to maybe by the time. If we could be ready to go at 5 to.
5 to, ma'am. The only thing I just wanted to say, to put down a marker in case it affects anyone's movements, it seems to me unlikely that we will get on sensibly to public rights of way.
I think that's probably the case. Mr. Millard, are you able? Sorry. Are you able to return tomorrow?
Yes,
You are. So I think what we probably will do is complete this section and maybe start with your section in the morning. Okay. I think that's probably the best way forward time wise. Okay. Right.
What time would you like to start?
We'll come back at 5 to. What I do also just need to mention
10
is.
to you.
Sorry, 10 to.
No, I was just teasing my learned friend.
There's another meeting in here this evening. I'll come to you in a moment, Mr. Sorry. And there's another meeting in here this evening, so we need to be out of here soon after 5 o'clock to give them a chance to set up.
Right.
Okay.
Thank you.
Sorry.
So that thing, I think this material Wednesday, I think normally the daily stages in quite a bit in the usual way. Basically, it's independent from the last previous. One matter I'd like clarification, and not give us on the Royal Commission I might like to make, which both council and applicant I follow in the document. Would it be appropriate if I mention that on resumption of your journey?
Yes, if you mention it then, and then that gives people a chance to, they might not be in a position to clarify it then, but I then want to get onto the appellant's side. But yes, certainly mention it at that point. Okay, thank you. This is kind of yeah. A1 is because I'm here.
No, so you don't. Yeah, that's fine. Yes, it's a local transport node. Yes, it's probably that. Yeah. Oh no, that's came for 20.
Yes, it's what, yeah.
Yeah, that's fine. Thank you.
Yeah.
Everybody's ready, we'll resume. Just before I hear from the appellant, my understanding is that whether contributions are paid by seal or section 106, that's a matter for the planning witnesses later in the inquiry, as is whether the contributions meet the seal tests in terms of proportions. So we don't go there today, essentially. Right, thank you. Mr. Hill, do you want to?
Thank you. Thank you very much indeed, ma'am. Yes, we'll try and complete this exercise if we possibly can by 5. In terms of documentation, there's just one additional pair of A4 sheets I'd like you to see, which I passed to learned friend and Miss Barron earlier. These are two documents prepared by Hampshire County Council that be used by Fareham Academy and Crofton School, simply called Travel to School Maps, and show travel isochrones. And when we come to D6, they might be of assistance. Otherwise, I'm going to try and work from the plan which the council have helpfully put up on the screen and supplied in hard copy form this afternoon, and also that schedule which I asked you might be able to have available in Mrs. Baker's main proof of evidence, appendices, Appendix C, which has got a useful summary of these items of infrastructure and both description and current position as at the exchange of evidence. It doesn't have a trigger column, and there are other items that obviously one could add and we will add, but I think it's a useful aide-memoire as we work through. And again, to try and keep things as simple as possible, I'm going to try and follow the order and format that the council have used for their presentation in the first part of the afternoon. So when you're reading your notes, this is as accessible as we can make it. Sitting to my right, of course, is Mrs. Baker, who will be making most of the running on these matters, and beyond her, Mr. Jones, who may have some comments to make, although I think most of the work will fall to Mrs. Baker. This is still work in progress, as you probably gathered, ma'am. There are some points that we just understood this afternoon in relation to some of the triggers in particular. And this is really our first attempt to set out for you, respectively, what the two main parties' positions are on these key issues. Oh, yes. Assuming Mr. Marshall won't want to have heard from us prior to making his contribution.
Yes, thank you, Mark. I didn't interject just back then because I think actually one of the matters that I was going to raise you may just have covered when you opened again. One of my queries was in relation to S106 and SIL, because we'd heard today almost exclusively in terms of delivery mechanisms reference to section 278 or section 106, no reference to SIL at all. So I just wonder whether the whole matter of SIL and S106 was being put on the back burner. It's actually not an issue anymore, but from what you've just said, that clearly does seem to be still maybe an issue and to be dealt with later. Am I correct on that? Yes, thank you very much for that. And the second was just an observation and a question that, whilst I can well understand the applicant seeking to have a section 106 agreement which sought a return on unexpended section 106 monies, is there a possible danger that in those cases, bearing in mind the delays you can have in the implementation of higher authority works, that you can end up with no payment being made, even though one ultimately maybe should have been required? That's just an observation point that I don't know, someone might want to pick up on. Thank you.
I don't know if Mr. Hill wants to respond now, but again, that's a matter that I think we would be looking at when we come on to the unilateral undertaking overall, that clause and mechanism. Mr. Hill, did you want to add anything?
No, I think that is exactly when we'll come back to that point, ma'am. And I have to say, as a matter of general approach, having a deadline by which the monies need to be expended is sometimes a jolly good thing.
Thank you, Mark.
So, ma'am, as I say, we're going to work our way through with the assistance of the council's plan and Mrs. Baker's schedule and notes made earlier today. And I think just in terms of an overarching position, Mrs. Baker, Inspector did ask you at the very end about the basis upon which the traffic modelling in the TA had been undertaken and the extent to which it builds in mode share in relation to some of the key alternatives to car transport. And perhaps you could just summarise the position in relation to the TA.
Yes, all of the modelling within the TA and the TA addendum, all of the junction capacity assessment work there is all based on flows that derived from the SRTM. The SRTM model does not factor in mode shift at all. My understanding is not even for public transport trips. The way that it looks, the highway component of the SRTM looks at public transport is it actually adds in delays if there are things like bus lanes added in. So it might affect routing and distribution, but overall it doesn't do anything to reduce the demand matrix, the trips. That's fixed.
Thank you. So it's very much a worst case.
Yes.
Let's look then at these various items on our list, and I'd like to start with A1, which is the Ramvilles Lane A27 junction. And just a short comment here, because as your schedule reveals, this has got a green wash over it to denote the fact it's agreed and works to be delivered under 278. One can see it is some way off from the appeal site. What is the issue there? It was summarised by the council on the basis that the impact was unacceptable. The impact of the development was unacceptable. Can you just remind us what the issue is for item A1?
Yes, certainly. This isn't a scheme that's in either the IDP or the LC WIP. This has been specifically identified as part of the application's transport assessment. So it's a standalone scheme relating specifically to development impact. The issue is that in the PM Peak, there's a right turn lane in the PM Peak. Yes, sorry. There's a right turn lane on the A27 into Ramvilles Lane. By 2036, with the development in place, the queue that would occur in that lane would be longer than there is physically space for. And that would have potentially a safety impact because you might get queuing vehicles sitting in the offside lane on the A27. So it could lead to rear end shunt accidents. So we've extended the right turn lane to have sufficient capacity to accommodate that queue. So it's more of a safety measure than the capacity one.
You. Nothing else on A1. And let's try to turn then to the group of interventions described in your table as B2, B3 and B4. Titchfield, Gyratory, St Margaret's Roundabout, Sexsworth Roundabout. And the schedule right-hand column reminds us that those aren't agreed. And I'd just like you pleased to respond to the council's contention that the appeal development gives rise to a severe residual impact at those three locations. B2, B3 and B4 is in fact off the map.
I think probably looking at B2 is the easiest way of demonstrating that the sort of levels of impact that the development is going to have at these junctions, because that's the closest and that's the one that will take the vast majority of traffic. It reduces as you get further from the site. If you go to the table at our 4.4, I think it was, of my main proof of evidence, that was there really to address queries from third parties, but it does usefully set out B2 being the Titchfield gyratory. It sets out what the queues at that junction are under observed 2022 traffic flows. So we built baseline models that we validated against observations, and that shows that in the morning peak, the queue the worst queue on the Titchfield gyratory was 18.1 vehicles. If we then go to Para 320 of my evidence, and the tables just following that, you can see there that in the morning peak in 2036, without this development proposal, the maximum queue increases to 187.6. So effectively a tenfold increase in queue between 2022 and 2036. In the next column, that shows the queues with the development, and that increases to 190.2. So the development proportionally adds very little to the queues at that junction. It's everything else that is happening between 2022 and 2036 that's causing the significant, impact in that location. And I think that's the point that I was trying to draw out in evidence, that relatively speaking, this development doesn't tip any of those junctions over the edge, doesn't add substantially to queue lengths or delays. It is an underlying problem that is a cause of traffic growth and wider local plan allocations. And that was why, because it's a strategic issue that is caused by lots of factors, was why, in my view, I'm starting to tread on others' toes here. My view that seal was appropriate because it was a strategic capacity issue that needed dealing with, irrespective of whether this development went ahead or not.
Yes, and I think that's reflected, isn't it, in the right-hand side of the table in your appendix C that we were looking at a moment ago. The appellant's position that SIL is intended to fund the borough-wide or strategic infrastructure as per the local plan. This should be funded via the SIL contribution from the site. And as you said, if you look at the actual impact from the development traffic, it is a very small proportion indeed, as at 2036, taking us from 187.6 to 190.2 in the AM peak. So just responding in summary in relation to B2, but let's assume that your answer applies also to B3 and B4 off the page. Do you accept that we have a severe residual impact arising from this appeal proposal at either locations B2, B3 or B4?
I don't.
So that's the AM peak, and on the next page you've got the PM peak. And when you're looking at the differences with the development in the PM peak, they seem to be a bit higher. Could you comment on that, or have I misread it?
So in the PM peak,
in the PM peak, we have, rather bizarrely, the SRTM actually shows.
Sorry, I can see what I've done. I've looked at the seconds reading the series. So, right. Thank you.
Thank you. So let's just go back to that schedule. You promised you'd take us to your tables, but I think that may be the only need for us to visit the detailed tables. C1 is in relation to the bus stops. I think with a little bit of clarification, we've agreed that, and that's part of the site access section 278 works. Nothing more to be said. And then we've got the D series of interventions, which are grouped on your table under the head D, pedestrian and cyclist provision. And we can take the green ones relatively lightly because the council's already explained where they are and what they're doing. There's still an issue in relation to D3 in relation to the means of delivery.
I think there is. I think in the UU it's been suggested that there is an either or condition requirement. So the developer at the time can choose whether to deliver those works via a 278 agreement or to provide the contribution identified by the Highway Authority.
Yeah. Thank you. And let's just move on then. D5 is the position in terms of the general discussion of D5 before we get to triggers. As does it remain as shown on your table? D5 works agreed, delivery mechanism not agreed.
Yes, again, that's the same as
D3 and D5.
the same as D3.
D3 and D5 you can group together.
Yeah, exactly. It's got the same with alternative delivery mechanism identified in the UU.
Yeah, and we'll come and have a look at in the sort of second tranche of questions at the second set of points that a friend asked his witness. But let's just work through the first run. D6 is one where I do want to pause for a moment. That's the pedestrian cycle routes to Crofton School. We can see D6 appears in two places on the A3 plan that we should all have out. This was introduced on the basis that Crofton School will be the school to which secondary school age pupils from the appeal development will travel. Is it as simple as that in your understanding? Like, go as far as you can. We've got Mr. Hunter on education coming along tomorrow, but go as far as you can in relation to what the assumption should be.
My understanding is that it currently is identified as the catchment school for the site being a greenfield, and that the Education Authority aren't proposing to change that. That decision, and I'm starting to stray outside of transport, but on a basis of looking at it in terms of transport, that decision seems a little perverse when the Fareham Academy travel map that I've just shared shows that the entire site is within an 8-minute cycle or 15-minute walk of the Fareham Academy, yet the site doesn't even fall within the map for the Crofton School. So
that's these two sheets that the County Council have produced in relation to travel to school isochrones, and just comparing the two, the Fareham Academy one captures the whole of the site, doesn't it, or the whole of the developed part of the site, or the part to be developed, allocated for development. As you say, the outer the outer line approximately 15 minutes walk, or is it 6 minute cycle?
Yes.
Would capture all of the developed area, and indeed some of the site would be 10 minutes walk or 4 minutes cycle ride.
Yes.
Whereas the equivalent plan that we prepared for Crofton stops really the top of the page. One can see the Subington bypass and Tanner's Lane and the fish ponds, and you start just to get into the developed area well outside the outer isochrone.
Exactly.
And the outer isochrone is the 20-minute walk, 8-minute cycle, isn't it? So we'll come back to that with education tomorrow, but I just wanted to give you the opportunity to comment on that point. Second point under that head, this issue of the evidence that is available in relation to the proportion of trips made by cycle to Crofton School. Have you had an opportunity to review any evidence on this?
So Ms. Ballerin kindly sent me on Thursday a summary page on the data that she'd been provided from the school census. I had a number of concerns, or a number of questions really, relating to it. I don't know the questionnaire that it was based on and what questions were asked. I was also concerned about sample size. The info you provided indicated they had 100% response rate, and I struggle to believe that, because you never get 100% response rate on a questionnaire survey, and whether or not that had been factored up and if there was any skewing within it. I haven't, unfortunately, been able to go out and do a survey and validate cycle usage myself. I didn't realise I would need to try and do that until Thursday last week, and unfortunately it's half term this week, so I couldn't pop out this morning and do it.
There we are. Let's just consider for a moment what the implications would be of 41% of pupils using cycle as a means of getting access to school in the AM peak. What would the implications be for the modelling that you've undertaken on the road network?
So in the the SRTM assumes 80% car mode share for all uses, all trips. So obviously that's way much higher than if you had that high level of cycle usage. And even our first principles assessment that HCC requested that we do, that included a breakdown of the residential trips by journey purpose, and we only assumed 1.3% cycle use for education trips. So clearly, if we had much higher cycle and walk mode share, our car mode share would come down substantially as well.
Yeah. Thank you. Now let's go back to the schedule D7, which is the works at the top of D1. Anything in particular you wanted to comment on that in general before we come back to it in the context of the triggers and apportionments and the mechanisms?
I think I've covered it, my position on it quite thoroughly in my proof, and why I don't believe it's necessary. I think the one thing I would like to point out is that while D1 has been mentioned previously, that D1 scheme, when it was discussed earlier, it wasn't mentioned that as part of that we're providing a shared footway cycleway on the northeast corner of the junction, a pedestrian cycle refuge in the centre of Peak Lane, and a pedestrian cycle connection back along to connect into Rowan Way, along with a parallel crossing across Longfield Avenue. In my view, those works alone mitigate all of the safety concerns at that roundabout. The cycle safety incidents all seem to be related to east-west movements through the junction. No, other way around. West-east movements through the junction and collisions with north-south vehicles. By putting that crossing to the north and taking cycles off, that movement can come away from the circulatory carriageway, and it mitigates that risk. So not just for any cycle demand from development, but also for existing cyclists carrying out that movement. There was also mention of the funding for that being related to funding that had come from the Crofton Cemetery site. My understanding was that that scheme was a capacity mitigation scheme, and wasn't specifically related to the LC WIP at all.
We will come back to D6 and funding. Sorry, D7 and funding when we run through the list again in the context of the triggers, mechanisms and apportions questions. So that was D7. And the other works that you were just describing at the top of Peak Lane that you say would effectively solve the issues there, not just for development movements, but existing movements, under which head would they be executed?
They're D1.
They're D1, yes.
Yes, under 278.
Yes, D1 is an agreed set of works, ma'am, and that would be provided pursuant to the 270. Yeah. So anything more on D7? You've explained that the D1 suite of works you think would deal appropriately with that end of Peak Lane, the issues in relation to safety of west-east movements, and constitute an improvement for both development traffic and existing traffic. D8 and 9 are matters that on the schedule you've indicated would be still related borough-wide or strategic infrastructure. Is there anything more you want to say at this stage about the concept of this sort of strategic-wide infrastructure? It appears on a number of occasions in the table. We've looked at B2, B3 and B4, but then it comes up again in relation to D8 and D9. Can you just give us a flavour of why, in your view, it would be appropriate for some of the £10 million that will be paid into the SIL pot by the site to be spent on those borough-wide schemes?
Yes, but I mean, both of these schemes are identified in the IDP as strategic non-capacity knock-on improvements, I think is the terminology used.
Say this again slowly.
They're identified in the IDP as non-capacity strategic knock-on improvements, I think is the term used. So effectively, and Ms Barron helpfully clarified the approach that HCC are taken. Their priority is away from the A27, I think, to look at measures that were going to encourage mode shift. And both of these schemes are identified as measures to achieve that, I think, is my understanding.
Okay.
And because they're strategic, it would make sense to me that they fall under SIM. They're slightly different to the B measures in that both of them are also in the LC WIP.
Yes.
So I think I've looked at them slightly differently in that I felt that D8 linked in quite well with the works that are being provided by the site to make those east-west connections. So I was looking at that more from an LC WIP function and improving pedestrian cycle connectivity rather than a knock-on capacity measure, if that makes sense. Whereas D9,
which is the Gudge Heath Lane.
Is Gudge Heath Lane.
Up to the north.
Exactly. That is on a potential alternative route from the site towards the town centre. but as the scheme is, this project is focusing on the route via the Gillies and upgrading along D3 and D5 effectively. I think it's unreasonable to expect a site to cover improvements to every potential route between the site and a location. If we're upgrading one, D9 isn't really required in my mind for PED cycle connectivity, and in capacity impact terms, my position on that is much the same as it is on B2. And if you do a similar comparison between the observe the flows, the queues now, and what occur in 2036 without us and with us in those tables in my evidence, I am of the view that we don't have a severe impact in that location, and it is a strategic issue.
Do you need to take us to the figures in your tables?
Again, A27 Redlands, Gudge Heath Lane, Morning Peak. We've got a.
Just give us a page.
It's power 4.4 again, table above that. That shows a queue, morning peak queue of maximum queue of 13.9 vehicles on any arm of that junction from the 2022 modelling. And if you then go to 3.14 and the tables above there, you can see that that goes up to, in the morning peak, 32.7. So almost a threefold increase. And then 33.9. With this development in place.
So is that the last line?
It is, yeah.
Those AM peak.
Yes, those are the biggest queues.
Yeah.
3.14.
The top table.
The top table.
Which is the AM peak one.
Bottom row.
Bottom row. Yeah. Increase of 1. Yes, so as you say, that is, you view that in a slightly similar way to B2.
I do.
Yeah. Good. Then just completing the initial run through before we go back to the triggers and apportioned approach, just leaves us with D10 and 11. Is there anything general you want to say about those?
No, I think things have moved on a little. I think we've agreed the sum for those two items.
That's the next exercise, the sums.
Sorry.
Is there anything general you want to say about those two measures?
I think accepting the need for those.
Right, now let's just, now we've visited the principles and we've made some general observations. Let's just go back and look at the more focused run through, which we did looking at the triggers, the mechanisms and potential for apportionment and the issues that arose when Ms. Ballaram was giving her observations on those. And we're conscious of the fact that there has been some movement since your table was prepared, and indeed that we're going to have a a subsequent table which crystallises the parties' positions and compares them in relation to some of these very detailed matters for the inspector, such as the triggers and the size of potential contributions if one were to proceed with an apportionment approach. Let's start with one which is nice and straightforward. That is in the green wash at the beginning of the table. What about the trigger for that?
Yes, I did an assessment that looked at adding traffic onto that junction iteratively to identify a point that the queue would fill up that space. That was about 800 units. Going in at 601 gives a little bit of leeway to make sure that if there's any sort of slight variations, that's dealt with. So I think we were happy to agree that one.
So works agreed, mechanism agreed, trigger agreed. Thank you. Then the B2, B3, B4, those off on the left-hand side, top left-hand side of the page, junctions that we talked about. We looked at the impacts that the development actually has on those junctions and how small they are. But if we look in a world where the inspector accepts that we need nonetheless to pay for works to be done there, reference was made to an 801 unit trigger point there.
I think I would need to go away and discuss that. Think about it and discuss in the round with everything else, as that was a new one to me.
Yeah, let's. I think that's the way in which it appeared when we were being taken through that. So that's fine. In relation to the suggestion that for the scale of the contribution, the council have worked out a proportion looking at HA 55 as a proportion of the likely other allocations running traffic, which would generate traffic through those junctions, but excluding sites of less than 50 units. What's your view on the appropriateness or validity of that means of deriving a contribution?
I think it's one way of looking at it. Is proportionate in relation to allocations and households. Clearly, you could look at it the way in the fact of the actual level of traffic that we're adding and the impact. And I've given my view on that already, specifically
very small.
B2, very small. In terms of proportionate, if you are going to use an approach that looks at basing it on residential unit numbers, I had a number of concerns with the approach that was taken there. It excludes site BL1, I think, completely, on the basis that the junctions are more distant from the town centre than they are from this site. Well, I think the Seggonsworth roundabout is probably not a dissimilar distance from our site to the edge of the town centre. Might be just under a kilometre difference. BL1, I think, which is the town centre, that was excluded.
In terms of the basket of sites that should be making a contribution or having an impact on B2. What about the concept of excluding all sites that are of less than 50 units?
Again, I don't agree the position on that, because the local plan policy specifically identifies that in TIN 4, I think the policy is that
TN4.
TIN4, all applications should be contributing towards IDP schemes, with the only exception being householder applications. So irrespective of size, there is a policy position from which the Highway Authority would be quite reasonable in asking for contribution even from small sites. There's also no allowance at all for the windfall expectations that were identified in the local plan, which is quite a considerable sum. And if small sites can contribute, there's no reason that they shouldn't. And it also assumes that the site is 1250 units, and while the allocation may be, this application is for up to 1200, and there remains part of the site, the allocation site, that could come forward in future and deliver that remaining 50 units or more.
And if one were taking a proportional approach, and we aren't ad item with the council on this, would there be any reason why that subsequent application coming in on the coattails of this application for 50 to 75 units couldn't be asked to make a proportionate contribution in the same way as us, if one were to take that approach?
No.
We know that the council's primary position, that even though there are these figures of 80%, 85%, which you said you don't agree with, is actually wants to ask for its the full cost of these works from us.
It does.
So regrettably, ma'am, on B2, B3, B4, we don't agree the principle. We don't agree the percentage, and we don't agree that you can wave aside the percentage and lay the full costs at the appellant in any event, or at the feet of the appellant, I should say. You're going to think about the trigger.
Yes.
So that's the Bs. Yes, just before we move off the Bs, there was a question put about what is the practical implications of not getting 100% out of us. And I think it was said that, well, the authority wouldn't have to worry about seeking contributions from other developments. And that is, of course, the case. But can that, in your view, provide a proper justification for discounting all the others who might be making an impact on the junction?
No, particularly, well, if you look at it in light of the suggested trigger point at 801 units, that's probably 8 years into the build out on the site. So there's quite a considerable time that smaller sites could come forward. Timescales being generally quicker for those through planning, that could fill in any gap.
Right. As I said, I wanted to move on to the Cs. The Cs, I think, are very straightforward, because these are the public transport facilities, the bus stops. The description is agreed, the mechanism is agreed, and the triggers agreed as well. Right?
I think there was a slightly different trigger to what we'd previously discussed, so I'll come back on that. I think the intention was that those would be delivered with the 278 works for the site accesses.
Right, so early on.
Early on for one.
Yes, understood. Thank you. Well, let's move on to the Ds then. And D1, D2, D4 are all coloured with the green wash. So in relation to what remains to be considered at this session, what's your view on the proposed triggers?
Again, I think I'm going to need to take those away. There are some factors that need to be considered on some of those 278 works. Generally, when doing 278 works, you'd want to go in and do the entire scheme in one hit rather than in a phased manner. Primarily, well, for lots of reasons, but multiple road space bookings becomes quite difficult. multiple mobilisations of contractors becomes, is an added complication. So how the proposed would work with the triggers that have been put forward today, we'd need to take away and have a think about.
Yes, because we want to be very concerned here with the practical delivery of this site, don't we?
Yeah.
Let's move on then to D3 and D5.
Is it worth, before you move on to there, talking about D2 briefly, which is the scheme that runs within the site?
Yes, by all means.
Again, I think I've set out within my evidence why that needs to be broken up into phases. You obviously are not going to want lots of construction traffic crossing those routes while those are being put in. So I think it's welcome that there's been a suggestion of looking at it being delivered in phases rather than all prior to first occupation. Again, I'll need to take the trigger points away. Sorry. I'll speak up as well. Yeah, I think it's welcome that a suggestion of splitting that into phases for delivery has been put forward by the Highway Authority. I think we just, again, need to go away and look at the triggers and how we tie those in with a phasing condition and different phases of development being brought forward.
We've got D2A, D2B and D2C at the moment. We come back on those. And I was asking you about D3 and D5 in respect of which those are the green marked routes east along Longfield and then north as well. Those are the works where the costs were referenced, £215 million and just under £1 million.
Yes, I mean,
and no apportionment.
I think we've accepted that those are works that would come with the scheme. And as I said earlier, I think in the UU we've allowed a mechanism where the developer or house builder that comes forward and takes the site forward could either choose to pay HCC a Section 106 contribution or could deliver the works themselves via a 278 agreement. And I think that the main benefit of including it and looking at it that way is it gives flexibility because of the issues that can come with producing detailed designs and going through the detailed approval process and then booking road space, etc. And then developer may choose to just pay the Section 106 contribution.
And we have to bear in mind, don't we, that these aren't easy things to deliver, and that in relation to, for example, ma'am, I don't know whether you saw this on your preliminary site inspections, Michael's Grove has a lot of existing parking and drop curbs and things that need to be handled in an appropriate way as part of the delivery process. And are you also taking away to consider the triggers on
Yes.
this?
Yes.
So then we move on back to D6 in the second suite of questions. The route to Crofton School, full cost 517,000. And then this issue of having to widen the Stubbington bypass to achieve the necessary widths for the island. views on the appropriateness of that approach? Anything more you want to say?
I think again, I've set it out, I think within my proof, there is an existing safe route to Crofton School that is all off carriageway and incorporates a controlled crossing facility. In my view, the use of a toucan crossing is safer than relying on teenagers to make a decision on whether it's safe to cross at an uncontrolled crossing. I also feel that the route via the bypass, shared footway, cycleway adjacent to it, benefits more from passive surveillance than the existing public footpath along Tanner's Lane, which if I lived on the site and I had a 12-year-old daughter, I think I would probably encourage them to use a route where they have got at least passing vehicles and can be seen, rather than a very lightly used track.
Thank you. Anything else on D6 then, or should we move on?
I think the only other complicating factor as well, obviously, I think the suggestion at the moment on phasing is that the site is likely to be built out from Peak Lane moving eastwards. And something that we need to consider in trigger points is that you've got to get quite a way into the site before D6 would actually be the shorter route, or materially shorter route. And delivery of those connections through the open space to the south of the built element of the site is not something that's likely to come early in the phasing, because you've got to get access through to those, and there's 3 phases before you're really back to where the school site is. So again, something that needs consideration in that trigger point.
Thank you very much. So that was D6. D7, you've already given us some observations on that in principle. Anything more you want to say in relation to the trigger or the sum, which was expressed by reference to the Crofton Cemetery contribution?
It's an LC whip scheme. The reference in the LC whip is just a Dutch style roundabout could be considered. It's not a particularly fixed scheme. In terms of trigger points, irrespective of me not believing that it's necessary, that would need to be considered quite carefully against the trigger points for D1, because you're effectively, it's 2 different schemes that are trying to achieve the same thing.
So that, and at D1 you mentioned the cemetery contribution.
Yes.
So the cemetery is already permitted, I'm assuming.
It's permitted. It was permitted at appeal. I think there's a £50,000 contribution that was made as part of the 106 for that site, and it was described as being for capacity and safety improvements.
And do you know what the trigger for providing those improvements is?
I would need to check back, but I can confirm for you.
What I want to understand is if they do that and you come and do D1, where do the 2 link, and what?
Yeah,
because having roadworks has an impact on the local community in itself. How the 2 fit together.
Again, that goes back to the point about 278 works being done in one hit rather than keep coming back.
Yeah.
Yes, with the view certainly on this side of the room that if it's possible and viable to do them all in one go, that's what we prefer to do. Anything more on D7, the roundabout? So D8 and D9 were expressed in terms of this second tranche of questions as D1 95% contribution and a trigger coming down from 401 to 261, and in relation to D9, which is that Gudge Heath Lane capacity scheme, that was 88%.
Again, I think I'd need to go away and think about that and take advice.
Yeah, so those two could go together really. And then in relation to the triggers, we've just left with D10 and D11, where there is some agreement in relation to the maths.
There is. I think we were comfortable with the sum that had been reached, but we reached almost identical sum using a different approach. I think we were about 2,000 different. So I think we said we're happy to accept the sum, but I don't think we accepted the principle of the calculation that was done by you to arrive at that sum. But that's by the by.
And anything on the trigger there? That's 401, I think.
I think we previously indicated we were comfortable at 401 for D11, but again, I will go back and check that, because we need to look at all of them in the round, I think.
Yes. But nice anyway to finish on a positive note of accord in relation to the maths for D10 and D11 and the trigger, which I think completes my run through. But I do express this very much as a preliminary take on our part from what we've just heard from the council. And I know there'll be further discussions behind the scenes in an effort to narrow further the differences between us and make your task more manageable.
Okay. So Ms. Baker, I've just got, I have got one question in relation to the D6. You mentioned about surveillance. Do you know what sort of surface is anticipated? Some sort of bound or?
At the moment, it's a concrete surface.
Concrete.
Yeah, it's a concrete road. I'm sure you'll see it on fire whenever you do the site visit. But most of the length of it is already a concrete. It's a metal surface, so it's. I think the council's scheme is just for a short section between Tanner's Lane itself and where the crossing point is, where there's currently a 2 metre wide hog-in path. I think they want that upgraded to a 3 metre wide tarmac path. Short section of.
And in terms of lighting, is there any lighting along there?
No.
No. Does the scheme include any lighting?
No, it doesn't.
No, I'm just thinking of cyclists using it this time of year.
Yes, on the streets and on really the city. There will be some visual impacts assessments that will be required in the budget.
Yeah. So I've got a few points that I just, while I've got both of you here together, that I just want to check. So the methodology for the transport assessment was agreed with the County Council. So no, a paper in front of it. The methodology for the transport assessment was agreed with the County Council.
Yes, so there was numerous assessments undertaken. One which is reported in the transport assessment, and then a following, an alternative, if you like, assessment, which was more focused on first principles methodology, which is specifically reported in the transport assessment addendum.
Thank you. And in making that assessment, you took account of the fact that there was a proportion of the dwellings occupied as a care home. They're just counted as occupied.
So, sorry, my mic wouldn't go on. So we've considered the care home as a separate entity. And then we'd assessed 1,200 units and we'd looked at affordable and private and flats and houses split, but we hadn't taken any specific account of any of those 1,200 units being extra care. So in the first principles assessment, we just assumed they're standard housing. From my experience on extra care developments, the peak hour trip generation is much lower because they're not going out to work. Yeah.
Can you, I'm just looking at the statement of common ground and it's just fact really. So I'm on page 7, paragraph 6.2, the junctions over capacity with the development in place in 2036, but they don't need to be mitigated, so that's fine. And then 6.3, over capacity without the proposal and performance of the junction is worse with it in place. So they're all got junction numbers. And I just, if I could, I'd like to relate them to the numbers we've got here. So the first one, junction 1, I gather that's B2. Is that's correct? If there's an updated statement of common ground, just putting it in brackets would help me. So junction 2, I think that could be A1.
A1, yes.
Yeah. Junction 5, I've got lost, I'm afraid.
That's D9.
D9.
Snap.
Thank you. And junction 6.
D11.
Yep.
D11. Right, thank you.
I think there's also junction, is it junction 8? No, Rowan Way. Yeah. D7, isn't it? Oh, right, I'm looking at 4.1, sorry. Yeah.
Is that right?
Yeah,
That's what I've been given. Okay. So the next couple of points are for the council. You've explained in your evidence why you feel that's the contribution from the appeal scheme is between 80 and 85% for the B2, 3 and 4 junctions.
Yes.
And I think in terms of the other schemes that could contribute, they're listed in this table.
In the appendix, yes, that's right.
And has any account been taken of any suppressed demand or
No, this is purely based on the proportions in terms of units.
Thank you. So paragraph 4.39 of your proof, you come up with a proportional payment of 63.16%.
4.39.
And I think, does that relate to the table above?
Yes, so that's a similar yet slightly different calculations, but the principles are the same. Obviously, these relate to the LC WIP schemes rather than the IDP.
Right, and therefore it's based on the number of non-committed dwellings rather than the number of allocated.
Correct, yes, same principle, yes.
I think that's covered what I wanted to cover. Mr. Marshall, did you have anything further?
No, nothing.
Thank you. So if that's the case, we'll speak tomorrow morning, unless there's anything Marty, I can see Mr. Hurrell.
Just very shortly, ma'am, there's a couple of points of a procedural nature. We're just thinking about housekeeping in terms of the documents that have come in during the course of the day. Would you like us to assign them a document reference? There is a section, I see, a document submitted during the course of the inquiry on the documents at all.
Yes.
Did you have that in hand already?
Probably have called them out, but have we had those submissions from the councillors yet? No. Right. So if I just say what I've got so far, and then I think as long as they're numbered sequentially, and we'll just add to that, don't leave gaps, just keep going in case they don't come in, we can give them a later number. So the document 1 is the council's opening. Document 2 is the updated table from Mr. Jupp. 3 is the appellant's opening. 4 is Mr. Marshall's submission. 5 is the plan showing the junctions, the plan that's on the screen. And 6 is the school travel plan. I've just, both documents, just one number. I think that's all I've got. If I've missed something, tell me, or tell me in the morning if it comes to light.
I think that's fine, ma'am. I was just hearing that the statement of common ground in relation to the additional agreed matters for education it is ready to be circulated. So
that's ready.
Yeah, I don't know whether we've got hard copies or whether it's just going to be added to the list of statements of common ground on the core documents. Do we have
It can go on the statement of common ground, but it should go on the inquiry document.
Yes, so that go under section D, I think it is, isn't it, for the statements of common ground? So that can go in overnight and hopefully be some assistance tomorrow.
And if there's 3 submissions come in, just give them the.
And then the only other thing to mention was Mr. Goodman is going to turn his mind to the things that arose from your your questions earlier in the day, there's not a long list of things for him to attend to. We've talked about the planning obligation, seeking to provide in the alternative for the Natural England off-site contributions, and also the need for a plan that helps you understand where various locations are that are referred to in the conditions and documents. I think ideally he would quite like to be discharged from the inquiry. Do you have any further matters that you would want to
have no further questions.
raise with him, so long as there's points? And the only concern I have is that Mr. Millard's, I think, still here, but I'd be anxious if you did entertain further ecological evidence with Mr. Goodman not here. But I imagine you'll take a fairly firm view on that at this stage.
There was no mention of anything of that nature in Mr. Millard's proof.
No. So in that case, he's got to head back up to Derbyshire. So we might let him head off.
And then I think the other matter that you will look at will be the section 278, how that's secured, the agreements. We don't need it for tomorrow, but we do need it later in the week. So is there anything else anyone wants to raise? No? Okay. I did say I'll give an indication of what we'll do tomorrow, so I think we'll start with public rights of way and Mr. Millard, and then we'll return to the programme. So that's the health contributions and obligations, and then the sport and recreation. Seem to mislay the next page. Okay.
If we've got time, the next thing was education, I think.
Education. Yes, education. So with the statement of common ground, do you have a hard copy? Or?
I don't think we have a hard. Do we have the means to get a hard copy of the up-to-date statement of common ground on education to the inspector? Yeah,
we could.
Yeah.
Oh, if it's tomorrow morning, it's just the case officer doesn't work. She starts at 6:30, but she's gone by 4:30. But if I could have a hard copy today, that would help. Thank you.
Thank you.
Would you at some point copy it to the case officer as well at Inspectorate? Thanks. Okay, so I'll see you tomorrow at 10 o'clock. Thank you. Are we not okay to leave documents, are we? No. Yeah. I've maybe left in my room, or they can. All right. Thank you.